come to order. Please turn off all cell phones and refrain from talking.
Good afternoon, ladies and gentlemen. And welcome. This is the culmination of months of hard work and challenging, but I hope also very rewarding experiences in the 2018 mock trial competition. Congratulations to all of you for achieving this final stage. I remember once as a young lawyer being told by someone that one of the ways to control the butterflies was to try and make sure that you got them to fly in formation. I have no doubt that you have now acquired that skill, and I look very forward to hearing your presentations. At this time, I'm not going to repeat the various instructions and rules because I think you probably know them by heart, and I know that my colleague went through them this morning. So I'm going to at this time turn to our scorers and ask them to introduce themselves, starting with Mr. Cravaro.
Thank you, Your Honor. Good afternoon. My name is Alan Cravaro. I am a former senior deputy public defender in the County of Orange. That means I practice criminal law and I have my own private practice.
Good morning, everyone. My name is Geraldine Lee. I'm the president of the Orange County Trial Lawyers Association. I've been an attorney for 24 years and practicing in Orange County. Good luck.
Good afternoon, everyone. My name is Jennifer Johnson. I have my own practice. I'm also an former ICU registered nurse. I do primarily medical malpractice on behalf of injured people. Thank you and good luck.
I'm Jamal Moberly. I'm a retired judge after 21 years on this court, and I'm now a mediator and arbitrator, and I love mock trial.
Good afternoon. My name is Lisa Mitz-Patrick. I'm a civil attorney. I've practiced for over 30 years. I've coached mock trial. This is such a fascinating process. I look forward to seeing how it all goes.
Hi everyone, my name is Danielle Mayer. I am a civil litigator at Buckalter, and I've been practicing for 5 years. Good luck.
Hi everybody, my name is Jim Cantone. I'm the incoming president of the Orange County Trial Lawyers Association. I've been practicing 27 years and focus on personal injury and product liability, and wish everybody the best of luck.
Thank you. I would now ask the attorneys to introduce themselves, starting with the prosecution.
Yes, Your Honor. Good afternoon, Your Honor. My name is Madison Price, and I'll be presenting the pretrial argument on behalf of the people of the state of California. At this time, our trial attorneys will introduce themselves.
Good afternoon, Your Honor. My name is Claire Munch, lead trial counsel on behalf of the people of the state of California. Today, I'll be conducting the direct examination of SWAT Officer Keegan Lopez and the cross-examinations of Marlo Patterson and Reagan Klein. I will also be presenting the closing argument.
Good afternoon, Your Honor. My name is Jenny Lopez, trial counsel on behalf of the people of the state of California. And today, I'll be conducting the direct examination of Sawyer Smith and Dr. Dakota Chung, as well as the cross-examination of Dr. Blake Williams. I will also be presenting the opening statement.
Good afternoon, Your Honor. My name is Brooke Donovan, trial counsel on behalf of the people of the state of California. Today, I will be conducting the direct examination of Cameron Holmes and the cross-examination of Sam Colossian. At this time, our witnesses will introduce themselves.
Good afternoon, Your Honor. My name is Tobias Grafensteiner, and today I will be portraying the role of Sawyer Smith.
Good afternoon, Your Honor. My name is Jedediah Hurst, and today I will be portraying the role of Cameron Holmes.
Good afternoon, Your Honor. My name is Caleb Jones, and today I'll be portraying the role of SWAT Officer Keegan Lopez.
Good afternoon, Your Honor. My name is Haley Teixeira, and today I will be portraying the role of Dr. Dakota Chung. At this time, our clerk will introduce himself.
Good afternoon, Your Honor. My name is Kevin Wong, and today I will be assisting the court as court clerk. At this time, may our coaches introduce themselves.
Yes.
Good afternoon, Your Honor. Elton Munch, student coach.
Good afternoon, Your Honor. Neil Wright, student coach.
Good afternoon, Your Honor. Riley Anderson, student coach.
Good afternoon, Your Honor. Alexandria Hurst, student coach.
Good afternoon, Your Honor. Matthew Cox, attorney coach.
Good afternoon, Your Honor. Aaron Heisler, attorney coach.
Good afternoon, Your Honor. Amy Siderud, teacher coach.
Would the defense like to introduce their team?
Yes, Your Honor.
Good afternoon, Your Honor. Volunteer scorekeepers, my name is Ashton Cho, C-H-O, pretrial on behalf of defense. Today I will also be Sam Pelosi. At this time, may my co-counsel please introduce themselves.
Yes.
Good afternoon, Your Honor. Volunteer scorekeepers, my name is Simply Seo, last name spelled S-E-O. Today I'll be presenting the opening statements on behalf of the defense counsel as well as conducting the direct examinations of Sam Pelosi and Marlo Patterson.
Good afternoon, Your Honor. Volunteer scorekeepers, my name is Timothy Seo, S-U-H, and tonight I'll be conducting the direct examinations of Reagan Klein and Dr. Blake Williams, as well as the cross-examination of Dr. Dakota Chum and Cameron Holmes.
Good afternoon, Your Honor. Volunteer scorekeepers, my name is Kanan Cossin, C-O-S-S-I-N. Today I will be conducting the cross-examination of Sawyer Smith and Officer Keegan Lopez, and I will also be presenting the closing argument. At this time, may our witnesses please introduce themselves.
Yes.
Good afternoon, Your Honor. Volunteer scorekeepers. My name is Julia Wimori, U-Y-E-M-O-R-I, and today I am Dr. Blake Williams.
Good afternoon, Your Honor. Volunteer scorekeepers. My name is Helen Park, P-A-R-K, and today I am Marlo Patterson.
Good afternoon, Your Honor. Volunteer scorekeepers. My name is Grace Ulibarri, U-L-I-D-A-R-R-I, and today I am Reagan Klein. If it's so please the court, may our bailiff please introduce herself.
Yes.
Good afternoon, Your Honor. Volunteer scorekeepers, my name is Rachel Lee, L-E-E, and tonight I am your bailiff. For the record, I have a copy of the playbook and rules if needed. If it so please the court, may our unofficial timekeeper please introduce himself.
Yes.
Good afternoon, Your Honor. Volunteer scorekeepers. My name is Isaac Kim, K-I-M, and today I am the unofficial timekeeper. At this time, may our attorney coach and teacher coach please introduce themselves.
Good afternoon, Your Honor. Volunteers, Christian Romero, attorney coach. Good afternoon, Your Honor. Volunteer scorekeepers, Justin Cox, teacher coach.
Right. At this time, I understand that the defense has a 995 motion in an effort to persuade this court to dismiss count 2, the criminal threat charged under Penal Code section 422. Does the defense wish to present a summary of its arguments?
Yes, before we begin, just a preliminary matter, do you have the latest copy of the errata? If not, our bailiff could provide errata number 4 for you.
Of what?
Of the latest errata.
Oh, yes, I do. Thank you.
Okay, then.
Thank you very much.
May I proceed?
Yes.
May it please the court, the defense moves to dismiss count 2 criminal threat as Ms. Rachel Klein's comment was protected free speech under section 2 of the First Amendment. Now, to determine whether Ms. Klein's comment was indeed a true threat, we must consider the 6 elements outlined by Calvin 1300 that requires of a statement to constitute a true threat. First, element 4 states that the threat must be so clear, immediate, unconditional, and specific. Yet the statement in question, however, does not contain any mention of when this threat might be carried out, nor how or with what the threat might be executed. The statement merely contains vague sentences such as, I'm coming for you, I'm going to get you, or I hate you. Hate crime is not a speech.
But now, when words are vague, can't this court, under the Supreme Court decision of In re George T., take into account the context, such as a history of animosity, in order to convert what would otherwise be vague comments not amounting to a true threat into a true threat?
Yes, I agree, Your Honor. George T. does outline 3 surrounding circumstances that must be observed when the comment is vague, and the 3 circumstances are the threatening gestures, history of animosity, and conduct suggesting the immediate possibility to carry out the threat. However, in this case, none of those 3 surrounding circumstances are present in the court today, and the date of August 14th will prove, and I will show you the evidence that there were none of those 3 surrounding circumstances. Would you like me to explain why there were no 3?
Yes, please proceed.
Now, as for the threatening gesture, the message was sent via electronic communication. So there was no threatening gesture, as a gesture is implicitly a physical form of communication.
How do you square DC versus RR with your case? Doesn't that case directly contradict the propositions that you're making? Because in that case as well, a computer keyboard was used, and the court held that amounted to a deliberate and careful decision to make the comments in question.
Yes, Your Honor. The case of DC versus RR stated that the statement was indeed a true threat because of the message and its transmission. But the case in DC versus RR is different from the case at bar because, as we can see in the case of RR, there was deliberation shown through the specific actions that the defendant had mentioned to carry out, such as bashing the victim's head in with an ice pick and the threat to kill that occurred 3 times present in the case of DC versus RR. However, in this case, there is no specific action for Smith to be fearful of, and there's no specific action that Ms. Klein mentions anywhere in the threats that she would carry out.
Please proceed. Thank you.
So instead, all we see in the comments is an angry Ms. Klein, simply expressing her emotions and frustrations, similar to the defendant in the case of Ricky T, in which the student who gets slammed in the face with the door by the teacher simply expresses his anger with a rude threat containing curses and the phrase, "I'm going to get you." But due to the statement's lack of immediacy, paired with the fact that this teacher had not made any calls to the police, the court upheld a ruling of not a true threat. Which leads to my second point, elements 5 and 6, which states that Sawyer Smith must be in a state of sustained and reasonable fear. However, the evidence of the day shows that Smith was not in fear, because in reply to Ms. Klein's comment, Smith, quote, laughed out loud, commenting as if, "You're done now, bye."
But Mr. Smith was very concerned with how he came across to the public, hence his sideline career as an influencer, right? Wouldn't he have had every intention to want to convey to his public that he was not particularly concerned by these words which were possibly intended to further humiliate him?
Yes, Your Honor, he did have a reputation to uphold, and so he did not want to show his fear to his followers. But this is not evidence for why Smith did not show or fear to his family or acquaintances, or to the police that are there to help Smith, and could do so in discretion. The argument for why Smith did not show fear to his followers cannot be applied to why Smith did not show fear to the police or the media.
How did he not show fear to his family?
We could see from the process or the events of August 14 that Smith, after receiving the threat, simply carried about with his day and ended the night watching a movie in bed, and as the statement says, without alerting anyone.
Thank you. Please proceed.
So we must consider Smith's fear that was involved. And in the threat itself, there was no clear action for Smith to be fearful of. Also, subsequent to the threat, we could see that Smith had gotten swatted that very night. But when Smith had gotten swatted, when she was in the ambulance, when he was going to the hospital, he immediately thought of Reagan Klein. Or he did not show fear because the swatting incident was not a direct correlation to the case at bar. The people will try to prove that the swatting incidents showed conduct suggesting to kill. However, that simply is not the case because Sawyer Smith must have been in fear from the statement itself directly and not from the circumstances itself that was the conduct suggesting to kill. Also, there was no history of animosity. There was a history between Reagan Klein and Sawyer Smith, yet not only must we consider the relationship between these two parties, we must consider the relationship between Sawyer Smith and that of the account of Hayden Carlton. And when we look at Mr. Smith's witness statement, he writes thus: "I was feeling on top of the world that I had finally beaten this stupid online attack by the fake Hayden Carlton account." So not only did Mr. Smith deem the true threat or the prior attacks by Hayden Carlton account to be stupid, he knew it was a fake, that it was meant to embarrass him. And on that same day, it was the same Hayden Carlton account that had threatened Sawyer Smith. So Sawyer Smith, knowing that, unfazed, wrote the statement, LOL. And it is for these reasons, because the threat itself lacked unequivocality and specificity, and immediacy, and because Sawyer Smith was not in a state of sustained or reasonable fear, that the defense requests that Your Honor grant us the 995 motion to dismiss count 2. Thank you.
Thank you, counsel. Does the prosecution wish to present a summary of this argument?
Yes. May I proceed?
Yes,
afternoon, Your Honor. The people respectfully ask that the defense's 995 motion be denied. The motion we are here for today discusses probable cause, and if there is any, it must be denied. The defendant threatened Sawyer Smith after months of rising animosity. A catfish account was created under the fake alias known as Hayden Carlton by the defendant and two fellow co-workers. At first, this account was used to bait Sawyer Smith into a fake online romantic relationship, and when that didn't work, the account was moved to purely embarrassment and harassment tactics. All of this came to a head when the defendant threatened Sawyer Smith by commenting, "You deserve to die. I'm going to get you for this. You just wait. I hate you."
But isn't it true that by saying you deserve to die, he's not saying he's going to accelerate the process of death? He's saying at some point in the future you deserve to die. He's not saying I'm going to kill you, right?
At the end of the threat, it says, "I'm coming for you. Watch your back."
But does that necessarily imply an intention to commit an act of violence as opposed to a further act of humiliation?
Not that specific line, but when you look at the entire context, it does give a gravity of purpose to the threat.
And what context is that?
There was a history of animosity for over a number of months, and there was a post-threat event where, as the people will prove in trial, the defendant did in fact send a false text tip to the East Flamingo Police Department, resulting in the SWAT team raiding Sawyer Smith's home, Sawyer Smith falling down a flight of stairs and suffering from great bodily injury.
So I can take the evidence tending to link, and that's all it does at this stage of the trial, Ms. Klein with, I can take that evidence of attempted swatting into account in determining whether or not this is a criminal threat.
Yes, because if we look at the case of People versus Martinez, there was a threat made, and the next morning a fire was started by the defendant at the victim's workplace, which was linked back to the threat and gave weight to the threat. And in our case, it only happened a couple of hours later. So following the ruling of People versus Martinez, our case has a fulfillment of a threat immediately.
Thank you. Please proceed.
When you're dead, no one will even miss you, you monstrous slime of a person. You think you can stick me with a $34,000 lawsuit and just get away with it? Watch your back, Sawyer. I'm coming for you. California Penal Code 422 states a true threat is made a true threat when the specific intent of the threat, made in writing, verbally, or by means of electronic communication device, is to be taken as a threat, even if there is no intent of actually carrying it out. And the threat must be so unequivocal, unconditional, immediate, and specific as to convey to the person threatened a gravity of purpose and an immediate prospect of harm or execution, therefore causing the victim to be in sustained fear. First, looking to the defendant's deliberation and intent. The defendant took time to think out, write out, and post.
Well, is that true? This generation seems to be able to text and type faster than they talk. How much deliberation does that take? And a transmission involves the pressing of a button.
Yes, if we look at the case of DC versus RR, it was deemed to be a true threat because of the amount of deliberation and intent it takes to write a grammatically correct threat at a keyboard for over a period of minutes.
Please proceed.
Does that answer your question?
You did.
Okay. Took time to think out, write out, and post a grammatically correct 6-sentence long threat. Following the case of DC versus RR, which was deemed to be a true threat because of the deliberation and intent, our case has deliberation and intent. Second, looking to a gravity of purpose, we have to look at all circumstances involved. The California Court of Appeals ruled in the case of People versus Martinez that a defendant's words can be vague if the action show an immediate prospect of harm or execution. In People versus Martinez, there is a history of animosity, a threat made, and a post-threat event where the defendant set fire to the victim's workplace, causing damage to the building. In our case, there's a history of animosity, a threat made, and a post-threat event, whereas I mentioned earlier, the defendant sent a false text attempt to the East Flamingo Police Department, resulting in Sawyer Smith being swatted. Following the ruling of People versus Martinez, our case holds a gravity of purpose. Third, looking to sustain fear felt by the victim. The defendant sustained fear by the victim. The California Supreme Court held in the case of People versus Chandler that a victim can be in sustained fear for his or own safety, even if they do not immediately report it, because it is common for victims to desire not to show it. In People versus Chandler, victim number 2 said, "Bring it on," in response to the threat, Yet, once it was later reported, it was deemed to be sustained fear.
Well, that's true, but in this case, that was the visible outward air of insouciance that the victim adopted. But the victim then went to bed and watched a movie. Didn't seem particularly perturbed by what he had read.
Yes, but as you earlier said to my opposing counsel, the victim was afraid of the reputation that they held on social media and wanted to preserve that they were not in fear after this account had been harassing.
Yes, which is why I'm distinguishing between the LOL, the response on the website, and what he did privately. What he did privately, his audience, the audience he was trying to impress, couldn't see what he did. He didn't seem to demonstrate any fear when he watched a movie that night, did he?
His actions did not show fear, but immediately after the swatting incident, when the situation escalated, so the victim did report the fear to Officer Keegan-Lopez. May I proceed?
Yes, you may.
In our case, Sawyer Smith might have responded with LOL as if you're done now, bye, but reported to the police immediately after the swatting incident. Did you see that psycho comment Reagan left me? I was totally freaked out, but I wanted to play chill so my followers would see. Showing us two things. One, that Sawyer Smith did not want their fear to be public knowledge, and that Sawyer Smith was in sustained fear for a number of hours after the threat was made. Following the holding of People v. Chandler, our case has sustained fear. In conclusion, Your Honor, the people respectfully ask that the defense's 995 motion be denied on grounds of probable cause. Thank you.
Thank you, counsel. Rebuttal?
Yes, Your Honor. May I proceed?
Yes.
Element 1 of the CalPERM and Element 3 of the CalPERM state that the defendant must willfully threaten with the specific intent that the statement be understood as a threat. This requires the people to prove that the defendant fulfilled the strict culpability requirement of the mens rea. But in her witness statement, we can see that she writes, quote, "In my haze, I commented something stupid on Sawyer's post. Looking back, it was a lot, but I didn't really mean it, and Sawyer knows that." So yes, Reagan Klein was negligent and reckless, but in no way did she intend to put Smith in any fear or harm. She did not intend to threaten Sawyer Smith. Now, as for the case of People v. Chandler, we can see that the people have brought up People v. Chandler to show that victims can show sustained fear and have sustained fear, even and make such statements like that.
Well, one moment, counsel. I'm more concerned about People v. Martinez and the evidence of the fire there being equivalent to the evidence of the text tip here. The fairly vague words used tend to become more serious and threatening if you combine it with the conduct of the text tip, of which there is some evidence.
Yes, Your Honor, but there are several distinctions from People v. Martinez and the case at bar. First, the supervisor called the security after receiving the threat, not after the arson incident. Second, arson was a secondary count to promote count 1, criminal threats, which was the primary incident and not the pretrial motion. And 3, because this threat was not the because the threat was the primary factor that must be considered when looking at the fear. And we can see that Ms. Sawyer Smith, not from the swatting incident, but from the threat, had not received any fear. We must conclude that Ms. Sawyer Smith was not in sustained fear as a direct result of the threat. And so the swatting incident must not be considered because the swatting incident is a separate matter, but also because the swatting incident, though it may have caused Sawyer Smith to be put in fear, is not what must be considered. The threat must be considered, and what the threat caused Sawyer Smith to be in harm or fear is the primary factor. And so Chandler, we could see that the victims in the case of Chandler took subsequent action, and thus that was the reason why the court deemed that they had sustained fear. However, in this case at bar, Mr. Smith has not shown any subsequent action that might indicate sustained or reasonable fear. After the swatting incident had occurred, Mr. Smith, when the SWAT team was banging on her door, immediately thought that a burglar had been trying to enter. She wrote, "I thought someone might be trying to break in and steal from me." Mr. Smith's immediate thoughts were not that of Ms. Klein or the comment, but he was more concerned for his possessions than for the safety of his own mind.
30 seconds.
And not only that, Mr. Smith was in his house behind bolted doors for the entire night without receiving any further statements, gestures, or conduct from his client indicating any action to carry out the threat. And it's for these reasons that the defense requests that Your Honor grants us the 995 motion.
Thank you, counsel. Rebuttal from the prosecution?
May I proceed?
You may.
Earlier in my opposing counsel's argument, they brought up the case of In re George T. But In re George T is distinguishable from ours. In re George T, there was no specific target as to who the threat was made out, and it was simply just poetry. In our case, this was a deliberate, intentional threat written on a phone keyboard, then sent, posted, and kept up on the victim's website. A more analogous case to ours would be the case of DC versus RR. As I brought up in my previous argument, where it was deemed to be a true threat because of the amount of deliberation and intent it takes to write a grammatically correct threat. Second, opposing counsel has said that swatting is not relevant in this case, but it is, because the 995 motion discusses probable cause, and if there is any, the motion must be denied. The swatting incident, and the defendant being charged with count 1 of false report of emergency, is probable cause. The defendant is suspect right now and is the key suspect in being charged with it. Therefore, it is relevant to our case. Third, opposing counsel has also brought up that there is no sustained fear, but I'd like to refer you back to People v. Chandler, where the victim did not immediately report it, but once it was reported, it was deemed to be sustained fear because of the circumstances. And in our case, there was a threat made, there was an escalating level of animosity, and there was a post-threat event where the victim's home had been swatted.
How do you explain the Jackson case? There was the threat of, to use an AK-47, far worse threat than what we have here. How do you factor that into your position?
People v. Jackson may be more grotesque and exaggerated, but it's distinguishable from our case because there was no previous animosity and there was no fulfillment of the threat, and the victims were not deemed to be in reasonable sustained fear. And in our case, we have a rising animosity, which would lead the victim to believe that this threat had a weight of purpose to it. We have a victim in sustained fear after the threat was made and said, "Did you see that psycho come and raping about me? I was totally freaked out, but I wanted to play a show." And there was no fulfillment of the threat, and it was not reasonable under the circumstances, but in our case, there was a fulfillment by the defendant sending the false text to him. Does that answer your questions?
It does.
Thank you. May I proceed?
You may.
Going to the case of People v. Chandler, where the victim did not immediately report it, but once it was reported, it was deemed to be in sustained fear. This is analogous to our case, because the victim did report to the police in the ambulance on the way to the hospital after their house had been swatted, saying, "Did you see that psycho come raping about me? I was totally freaked out." In conclusion, Your Honor, the people respectfully ask that the defense's 995 motion be denied on grounds of probable cause. Thank you.
Thank you, counsel. You have 30 seconds to confer to determine whether there were any irregularities. Does anyone wish to report any irregularities?
None, Your Honor.
Nothing, Your Honor. Thank you.
Right, then the court will now deliver its ruling on the pretrial motion. Ms. Klein's speech did not constitute a true threat, and so it is protected speech under the First Amendment. Comments lacked the immediacy required to constitute a threat under Section 422. The use of words such as "you deserve to die" are not the same as words immediately threatening death or bodily harm. And there was no other conduct to suggest that the comment was a serious expression of an intent to inflict bodily harm, as opposed to further social humiliation or anger. Finally, the statement did not reasonably and subjectively cause the victim to be in sustained fear. The victim's subsequent conduct in casually watching a movie and not immediately reporting the threat suggests he was not in sustained fear. The court accordingly grants the 995 motion and dismisses count 2 from the information from the complaint. Thank you very much, counsel. We will now proceed with the trial. Would the trial team like to come forward? Does either side wish to present their exhibits for inspection to the other side, or has that previously been done?
Your Honor, the people would like to pre-mark exhibits A through E as exhibits A, B, C, D, and E respectively.
Yes, they'll be so marked. Nothing from the defense side.
No, Your Honor.
Right. The charges are as follows. The people of the state of California are charging the defendant, Reagan Klein, with reporting a false emergency in violation of California Penal Code Section 148.3. The people also charge Reagan Klein under count 2 with the making of a criminal threat in violation of California Penal Code 422. I will not repeat the elements of those two crimes because I suspect that counsel on both sides are very familiar with the elements of those crimes. Does the prosecution at this time wish to make an opening statement?
Yes, Your Honor.
Please proceed.
On the night of August 14, 2018, a heavily armed squad of police officers kicked in the door of Sawyer Smith's house. Sawyer, with intense emotions of fear and confusion, came to the edge of the staircase, looked down, and faced gun barrels pointed directly at him. He was so frightened, he slipped down the staircase and broke his foot. In reality, there was absolutely no illegal activity occurring. There was no reason for these police officers to be there, but they were. And the evidence will show that the defendant, Reagan Klein, had sent them there. In 1697, William Congreve wrote, "Heaven has no rage like love to hatred turn, nor hell of fury like a best friend scorn." The evidence, the witness testimony, and the people will prove that the defendant is that best friend scorned. 2 months prior to this incident, Sawyer Smith went viral on social media. He gained over 150,000 followers and was offered a brand deal from a local company. Within another week, his follower amount doubled and his brand offers tripled. Sawyer Smith, a typical community college student, had transformed into an idolized social media influencer overnight. After his rise to fame, Mr. Smith dropped the defendant as a best friend. Sawyer Smith moved on with his life, but the defendant could not. On July 2nd, 2018, he received a message from a girl named Hayden Carlton. The evidence will prove that the defendant and fellow co-workers created a gang and created this fake account in order to trick and humiliate Sawyer. When this plan failed, things only escalated from there. Throughout this trial, you will hear testimony from Officer Lopez that he admitted to arresting Reagan Klein for admitting to sending a threatening comment. And a forensic linguist, Dr. Dakota Chung, will sit before you today and provide evidence that proves the defendant wrote the false text to him. Your Honor, at the conclusion of this trial, the people ask that you find the defendant guilty of the verdict. Thank you.
Does the defense wish to present its opening statement at this time?
Yes, Your Honor.
Please proceed.
August 14th, Reagan Klein clocked into work, prepared to do what she did best, faithfully serve customers. She was striving for her dream by attending the University of California and working alongside companions whom she could trust. However, when she walked into the restaurant, she was fired from her job as a result of a feud between her and her longtime friend Sawyer Smith, who was seeking revenge. And today, this client finds herself in court, falsely accused of making a false report of her emergency. Today, the prosecution must prove beyond a reasonable doubt that Reagan Klein is guilty. But Your Honor, actions speak louder than words. The actions of Reagan Klein show that she would never bring harm to anyone. The facts and evidence will demonstrate that my client has been wrongfully accused because there were others with just as much means, motive, and opportunity. Today, the court will first hear from Dr. Blake Williams, a skilled forensic linguist who will testify that due to the vocabulary choices of the text tip, the author of the tip could not have been Reagan Klein, but is instead most likely Cameron Holmes. Second, the court will hear from Marlo Patterson, Reagan's longtime co-worker. Ms. Patterson will lay out the chronology of the event that took place on the nights of August 14th, and thus provide the court with evidence as to why the text culprit is not Reagan Klein, but Cameron Holmes. Third, the court will hear from Sam Kolosian, Reagan's former manager who has known Reagan for the past 5 years. Mr. Kolosian will testify to Reagan's kind heart and how a few days before August 14th, she was disturbed by a news story that showed the consequences of swatting. Lastly, the court will hear from Reagan Klein herself. She will share about her friendship with Marlo and how Cameron was utterly jealous of his friendship. Furthermore, she will testify that on the nights of August 14th, she only ever touched Cameron's phone to quickly check the time. Today, the prosecution must prove beyond a reasonable doubt that Reagan Klein is guilty of making a false report of an emergency. But Your Honor, the case before us today is full of doubt. Thus, there is only one certain verdict. Reagan Klein is not guilty. Thank you.
Thank you, counsel. First witness for the prosecution.
The people call Sawyer Smith to the witness stand.
Sawyer Smith, please stand. Please raise your right hand. Do you solemnly affirm that the testimony you are about to give will faithfully and truthfully conform to the facts and rules of the mock trial competition?
I do.
Please be seated. Please state your full names, spelling the last for the record.
Sawyer Smith, S-M-I-T-H.
May I proceed, Your Honor?
You may.
Good afternoon, Mr. Smith.
Good afternoon.
Can you please introduce yourself for the court?
I'm Sawyer Smith, I'm 22, and I'm a social media influencer.
And what social media platforms are you active on?
Well, I have an Outpick account and a Blab account, but the Outpick account is the one that went viral.
And when exactly did your Nowpick account go viral?
June 1st. All it took was one selfie.
What aspect changed the most after you reached fame?
Well, I really decided I had to take a good look at my life, which meant reevaluating some of my relationships.
What relationship was affected the most?
Mostly my relationship with Reagan Klein.
How so?
Well, I ended our friendship with her because she really didn't fit my brand.
But did you still speak with the defendant about your social media achievements?
I did. I spoke with all my coworkers about them.
Mr. Smith, are you aware of what catfishing is?
I am. It's when someone lures you into an online relationship using a fake online persona.
And have you ever interacted with a catfish account?
I have. Hayden Carlton.
Did you develop a relationship with Hayden Carlton?
Oh, well, I really thought I did. We talked for weeks.
Did you ever plan on meeting Hayden?
I did. Hayden asked me out on a date, and when I was stood up, I realized that I had been catfished.
And how, if at all, did the account change after this fake date?
Well, it went from just catfishing to the account posting horrible pictures of me with mean captions and just straight up lies.
Did this account have any effect on your brand deals?
Well, I actually did gain followers from it, but it was...
Objection, Your Honor, relevance.
May I be heard?
Yes.
I asked this question to establish that The defendant's plan to trick and humiliate Sawyer with the Hayden Carlton account failed, which escalated the situation.
Would you like to be heard?
Yes, Your Honor. It's still irrelevant to the fact at hand, which is if Ms. Klein sent a false report of an emergency.
Overruled.
Did you answer my question, Mr. Smith?
No. I actually gained followers from it, but it was never worth the emotional trauma that I
Mr. Smith, would you pull the microphone slightly towards you or scoot forward a bit? Thank you.
Now, Mr. Smith, did the account ever post anything that revealed the person behind it?
It did. The account posted about a story that only Reagan and I knew about. So I...
Objection, Your Honor. Speculation as to the fact that only Reagan and I knew about the account.
Would you like to be heard?
Yes. I believe that my witness can testify to his own thoughts. That is not speculation.
Do you have an offer of proof for the court?
Yes, Your Honor. This shows the witness's subsequent conduct. He believed that it was the defendant. Therefore, he reacted to this, which only started even more...
What's the basis for that belief?
For the belief of the question?
For the belief that it was the defendant?
Oh, well, witness will testify that the defendant posted a story that him and the witness only knew about. Mr. Smith never told this story to anybody. He only told it to the defendant. Therefore, he knows that it's the defendant who is behind the catfish account.
Your Honor, may I be heard?
You may.
It is still speculation. Just because Mr. Smith did not tell anybody else about the incident does not mean that nobody else knew about the incident, either through witnessing or Ms. Klein.
May I be heard?
No, the objection is overruled.
Did you finish answering my question?
The account posted about a story that only Reagan and I knew about, so I figured it had to have been Reagan.
And what did you do next?
Well, at first I really tried to pretend like nothing happened to keep up my image for my brand. But eventually I decided that enough was enough, so I told our boss Sam that Reagan had broken our oven over New Year's.
What did your boss do with this information?
Well, when Reagan came into work the next day, she fired her and threatened her with a $34,000 lawsuit.
And did you witness this event?
I did.
What, if anything, did you do after?
Well, it was a little petty, but I posted a victory picture on my NowPick account.
And was this targeted to the defendant?
It was.
Did the defendant react to this post?
She did. She threatened me.
And what did this comment say?
Well, she said, "You deserve to die. I'm going to get you for this. You just wait. I hate you. When you're dead, no one will even miss you, you monstrous slime of a person. You think you can stick me with a $34,000 lawsuit and just get away with it? Watch your back, Sawyer. I'm coming for you."
More importantly, Mr. Smith, did you feel threatened?
Objection, Your Honor. Relevance. May I explain?
Yes.
Count 2, criminal threat, has been dropped through the pretrial motion, and it is not a criminal threat. Therefore, his testimony as to whether he was threatened is not relevant to the case at hand.
May I be heard?
Yes.
This comment was posted the same day the SWAT team showed up at Mr. Smith's house. It is relevant.
So it's not relevant to count 2, which is no longer
Of course.
a part of the
But it's
complaint.
relevant to show that it happened, it's relevant to establish the timeline, Your Honor.
Just the timeline?
Yes.
Do you wish to be heard?
Yes, Your Honor. If it is just establishing the timeline, it is more prejudicial than probative, because the prejudicial value that the quote itself contains substantially outweighs the probative value in establishing the timeline.
May I be heard?
Yes.
I don't believe it's prejudicial. It does,
It's not unduly prejudicial.
yes.
Why not?
Because although it does have an effect on the defense's narrative, it does prove that the defendant wrote this threatening comment, that Mr. Smith was threatened, and goes to show how the defendant possibly did send a SWAT team to his house.
So you're suggesting it's still relevant to motive, even if
Yes.
the comments do not amount to a criminal threat, as that is defined under the law?
Yes.
The objection is overruled.
Did you finish answering my question?
No, I really thought Reagan was going to hurt me.
And Mr. Smith, what happened that night after the defendant sent the threat?
Well, I was lying in bed watching TV, trying to get my mind off of things when the SWAT team kicked in my door.
What happened next?
Well, I ran to the top of the stairs thinking that someone had broken in, when I guess I was so scared I fell down the stairs.
Did you speak with any of the officers regarding the threat?
I did. I talked with Officer Keegan Lopez about it.
Thank you, Mr. Smith. I have no further questions, Your Honor.
Cross-examination?
Yes, Your Honor. May I inquire?
You may.
Good evening, Mr. Smith.
Good evening.
Mr. Smith, you've been friends with Miss Reagan Klein for 8 years, haven't you?
I had, yes.
You had, and then you decided to drop her as a friend, true?
I did.
Now, Mr. Smith, you say that Miss Klein lied about breaking your boss Sam's oven, don't you?
She did.
But didn't you lie to your boss for 8 months as well?
It wasn't my responsibility to tell.
But you didn't tell your boss, did you?
No, I didn't.
So you did lie, correct?
No.
Mr. Smith, you didn't tell your boss?
No, because it wasn't my responsibility to tell her.
So you deceived your boss?
I suppose
Objection, Your Honor, relevant and argumentative.
Do you wish to be heard?
Yes, Your Honor, this is relevant because it goes to show the witness's character of dishonesty.
Anything further?
I submit, Your Honor.
Objections overruled.
Mr. Smith, please answer my question. You lied to your boss for 8 months, correct?
I suppose I didn't tell her the truth, no.
Yes, that's right. And then when you decided to tell your boss, you told Mr. Koloshkin that you had just found out that Miss Klein broke your oven, correct?
I did say that, yeah.
But you had actually known for 8 months that it was Miss Klein?
Yes.
So you lied to your boss once again, didn't you?
Yes.
Now, Mr. Smith, you've been wrong about Miss Klein before, haven't you?
No.
Objection, Your Honor, vague and ambiguous.
Sustained.
Mr. Smith, you thought that Miss Klein took the friend dropping well, true?
I thought she took it well.
But you were wrong about that, weren't you?
Yes.
So you have been wrong about Miss Klein before, correct?
I suppose so.
And despite the fact that you've been wrong about Miss Klein before, you're still convinced that she sent the tip?
Absolutely.
But nobody told you Miss Klein sent the tip, did they?
Objection, this question calls for testimony outside of Mr. Smith's witness testimony. Calls for information outside of the witness's testimony.
Do you wish to be heard?
Yes, Your Honor. Mr. Smith claims that Miss Klein sent the comment, but Mr. Smith was in his apartment and nobody told him that Miss Klein sent the tip.
Are you objecting on the basis of it being an unfair extrapolation? Is that
Yes,
your
Your
objection? And you are suggesting to the court that it is a fair extrapolation for him to, for you to accuse him of not knowing who sent the text tip because no one told him. Is that right?
Yes.
The court finds that the extrapolation is fair.
Mr. Smith, on the night of August 14th, you didn't see Miss Klein send the tip, did you?
No, I didn't.
Thank you. No further questions, Your Honor.
Redirect?
Yes.
May I proceed? Mr. Smith, why did you choose to wait to inform your boss about the oven?
Well, like I said, it wasn't my responsibility. I figured if Reagan wanted to come clean about it, then she would.
And despite the fact that no one told you the defendant wrote the false text tip, do you still believe it is true that the defendant wrote it?
Oh, absolutely.
Thank you. I have no further questions.
Thank you. Mr. Smith, you may step down. You are excused. Next witness for the prosecution.
Your Honor, the people call Cameron Holmes to the stand.
Cameron Holmes to the stand.
Please raise your right hand. Do you solemnly affirm that the testimony you are about to give will faithfully and truthfully conform to the facts and rules of the Most California Prosecution?
I do.
Please be seated. Please state your full name, spelling the last for the record.
Cameron Holmes, H-O-O-M-E-S.
May I proceed, Your Honor?
You may.
Good evening, Mr. Holmes.
Good evening.
Would you please introduce yourself to the court?
My name is Cameron Holmes. I'm 23 years old and I work at NSC's.
And are any of your coworkers in the courtroom tonight?
Yes. Sawyer Smith, Marlo Patterson, and until recently, Reagan Klein are all my co-workers.
And could you please describe your relationship with Mr. Smith?
Mr. Smith is my co-worker, but he recently became obsessed with his non-bank account.
What do you mean by obsessed?
It was all he would talk about. He bragged about his popularity, boasted about his brand deals, and became really annoying to work with or be around.
And how did you respond to Mr. Smith's new behavior?
Well, I'm ashamed to admit it, but after about a month of Sawyer's new behavior, Reagan came up with the idea to catfish Sawyer, and Marlo and I agreed.
And could you please describe your relationship with Reagan Klein?
After Sawyer dropped Reagan as a friend, she joined Marlo and I in our group activities.
And why did you agree to help the defendant catfish Mr. Smith?
Well, I did it at the time because at the time I believed that Sawyer could stand to be knocked down a peg or two. In the end, though, I have no beef with Sawyer.
And Mr. Holmes, to your knowledge, who had access to the NowPick account used to catfish Mr. Smith?
Reagan, Marlo, and I all had access, but Reagan used it the most.
Your Honor, may this witness approach the exhibits?
Yes, he may.
Your Honor, may this witness rearranging so that Exhibit E is showing?
Yes.
Now, Mr. Holmes, on the night of August 14th at about 9 o'clock of this year, what were you doing?
I was watching TV at Reagan's apartment when Marlo sent me downstairs to pick up the pizza he ordered.
And
I ended up waiting almost 10 minutes for that pizza.
And was anyone else besides Marlo Patterson present in the apartment on that night?
Yes, Reagan Klein was there as well.
And what did you do right after picking up the pizza?
I came back upstairs with the pizza.
And where was Reagan Klein standing?
Well, when I went downstairs, she was sitting by the dining room table. But when I came back upstairs, she was standing by my phone, Veritas phone.
And what did you see the defendant doing with your phone when you came back upstairs?
She was holding my phone, closing it shut, and putting it back down on the table.
Your Honor, may this witness be seated?
Yes, you may be seated.
Your Honor, the people move Exhibit E into evidence.
Any objection?
None, Your Honor.
Exhibit E is received.
Thank you, Mr. Holmes. No further questions, Your Honor.
Cross-examination.
Yes, Your Honor. Good afternoon, Mr. Holmes.
Good afternoon.
You used to be friends with Reagan Klein, correct?
I did, yes.
Back in June, she started hanging out with you and your best friend Marlo Patterson, right?
She did.
Now, Miss Patterson and Miss Klein went to the same university, correct?
They did, yes.
And they also had many inside jokes too, right?
It seems that way, yes.
They started leaving you out, didn't they?
It felt that way.
And this made you think that Miss Klein was trying to steal your best friend, correct?
It seemed that way.
Is that a yes to my question?
I suppose, yes.
Now, according to Marlo's Yum Yum delivery history, the pizza was delivered at 9:02 p.m., correct?
Objection, Your Honor. This question calls for hearsay and lack of foundation on behalf of the exhibit.
May I be heard, Your Honor?
Yes, you may.
This statement is not being used for the truth of the matter asserted, but to show Mr. Holmes' belief on when the pizza was delivered.
And do you wish to be heard?
Your Honor, I believe opposing counsel was using it to prove the truth of the matter that the pizza was delivered at 9:02 p.m. on that night.
What is the relevance of whether he believed, Mr. Holmes believed it was delivered at 9:02?
Excuse me?
What is the relevance of his belief that it was delivered at 9:02?
Well, Your Honor, Mr. Holmes claims that the pizza was actually delivered almost 10 minutes after it was marked as delivered, according to Marlo's Yum Yum delivery history.
Your Honor, that's what this witness believes, therefore he can testify to it. I'm not sure how that goes to...
The objection is overruled.
Thank you, Your Honor.
My objection to lack of foundation as to this witness knowing about the 902.
Yes, that's overruled.
So, according to Marlowe's Yum Yum delivery history, the pizza was delivered at 9:02 p.m., correct?
I'm not sure.
According to the delivery history?
I haven't seen this delivery order you're talking about.
But in your witness statement, you claim that you don't know why it was marked as delivered at 9:02. Don't you say that in your witness statement?
Well, Officer Keegan Lopez asked me about some delivery order, and I answered his question about that one.
Objection, Your Honor. The witness is being non-responsive.
Overruled. Perhaps you'd like to rephrase your question.
Moving on.
The parties are all aware of the stipulation as to Exhibit B being a business record, right?
Yes, Your Honor.
Please proceed.
You claim that the pizza was delivered almost 10 minutes after it was actually marked as delivered, correct?
That is correct, because I was waiting downstairs for almost 10 minutes.
And you didn't have your phone at that time, correct?
I did not.
So you could not check the time on your phone, right?
I could not, but I am adamant it was almost 10 minutes.
Now, earlier that night, you had overheard Miss Klein talking to Miss Patterson, correct?
I believe I did hear that, yes.
Miss Klein was saying how she was excited to go back to university with Miss Patterson, right?
That sounds about right to me.
This was so that they wouldn't have to put up with you crashing their hangouts all the time, correct?
I do believe I heard that, yes.
And then that very night, you told Officer Lopez that Mr. Smith had gotten Miss Klein fired, correct?
I believe I did, yes.
And you also told Officer Lopez that you had seen Miss Klein touching your phone, correct?
I did see Miss Klein holding my phone.
And Miss Klein was eventually arrested, correct?
She was, yes.
Thank you, Mr. Holmes. Your Honor, I have no further questions.
Redirect.
No redirect, Your Honor. May this witness be excused?
Yes, you may be excused, Mr. Holmes, and you may step down. Prosecution's next witness.
The people call Keegan Lopez to the stand.
Keegan Lopez to the stand.
Please raise your right hand. Do you solemnly affirm that the testimony you are about to give will faithfully and truthfully conform to the facts and rules of the mock trial competition?
I do.
Please be seated. Please state your full name, spelling your last for the record.
Keegan Lopez, spelled L-O-P-E-Z.
Your Honor, before I begin, may I inquire as to the time remaining?
Yes.
The prosecution currently has 7 minutes and 15 seconds. As for the defense, has 5 minutes and 35 seconds.
May I proceed?
Yes.
Good afternoon, officer.
Good afternoon.
Could you briefly introduce yourself to the court?
My name is Keegan Lopez. I've been an officer with the East Flamingo Police Department for about 20 years. My current assignment is with the Special Weapons and Tactics Team, or SWAT team.
Now, officer, were you on duty on the night of August 14, 2018?
Yes, I was alerted of a high-risk hostage situation from an anonymous text tip that we later determined to be of the address of Sawyer Smith's.
Now, officer, did you read the text tip?
Yes, ma'am, I did.
Your Honor, may the witness rearrange the exhibit so that Exhibit A is shown?
Yes, he may.
Now, officer, did you read Exhibit A?
Yes, I did.
And is Exhibit A an accurate depiction of the text tip you received on that night?
Yes, it is.
Your Honor, the people would like to move Exhibit A into evidence.
Objection, Your Honor, hearsay as to the grounds of bringing an out-of-court document into the trial.
May I be heard?
Yes, you may be heard.
Your Honor, we're not bringing it in for the truth of the matter as it is a false text tip, but for many different reasons, such as the the author's state of mind, and many witnesses' subsequent conduct.
Your Honor, may I be heard?
Yes.
The defense is not objecting to bringing to the words themselves of the message, but to bringing the out-of-court document into court. And there has been a lack of foundation as to this document.
May I be heard?
Yes.
Your Honor, I believe the witness has testified that he read the full text tip as an officer would typically read the text tip they received, and that Exhibit A is an accurate depiction.
Your Honor, may I be heard?
Yes.
In order to bring this document into court, the prosecution must lay foundation in 3 different ways. First, they must prove that it was made in the regular course of business. Second, they must show that the writing was made at or near the time of the event. And third, they must show that the sources of the information and method of preparation are trustworthy, and they have failed to lay the foundation for all 3 of these.
Yes, the objection is overruled, and you are seeking to have Exhibit A received in evidence?
Yes, Your Honor.
Exhibit A is received in evidence.
Now, officer, how did you respond to the text tip you received?
My team and I deployed immediately to the address depicted in Exhibit A. We then surrounded the house and tried multiple times to alert anybody inside of our presence at their door.
Was any response heard?
Despite multiple attempts, there was none.
After no response was heard, what, if anything, did you proceed to do?
We then proceeded to forcefully enter the building, and then we saw a man at the top of an interior staircase. When we told him to freeze, he was startled and fell down the stairs and injured himself.
What, if anything, happened after this unfortunate incident?
Well, after we cleared the rest of the residence and determined the text tip to be a false alarm, and then accompanied the victim in the ambulance to the hospital.
On the ride to the hospital, was the victim conscious and alert?
Yes, he was, and seemed noticeably afraid and kept repeating, "I know who did this. It was Reagan Klein. Reagan did this."
Objection, Your Honor, hearsay.
Your Honor, may I be heard?
Yes, you may.
This testimony is not going to show the truth of the matter, simply the officer's subsequent conduct, and it falls under the exception of excited utterance and state of mind. It goes to the state of mind, Your Honor.
Well, let's look at the subsequent conduct basis exception upon which you rely. What subsequent conduct do you contend the testimony shows,
Your Honor,
supports?
after the officer heard Sawyer Smith, the victim, give this information, this was his only lead at the time, so therefore he followed up on this information by going to the defendant's residence and investigating the rest.
So the comment isn't coming in for its truth, but merely to show why it is he then went to see Miss Klein.
Yes, Your Honor.
Your Honor, may I be heard?
Yes, you may.
Your Honor, the probative value in laying foundation for Officer Lopez's subsequent actions is substantially outweighed by the undue prejudice of the words themselves, which say, quote, "I know who did this, it was Reagan Klein, Reagan did this." In addition, the officer had other means to base a conclusion, to go to the defendant's apartment, so this testimony does not need to be admitted for laying foundation.
The court will take that into account in evaluating the testimony prior to delivering its verdict, but the objection is overruled.
Did the victim say or show you anything else at the time?
Yes, he showed me a very threatening comment sent by Reagan Klein.
Objection, Your Honor, relevance as to Officer Lopez's opinion that the message sounded threatening.
Do you wish to be heard?
Your Honor, opinion testimony is allowed if it's going to show emotions of another witness. Therefore, the officer talking about what Mr. Smith acted like or how he seemed in regards to the threat is definitely relevant in this case, Your Honor.
How is the officer's opinion as to whether the text sounded or seemed threatening relevant?
Your Honor, as an officer of the law, I believe he is allowed to testify that he thinks the comment is threatening. And this is also why pardon me, Your Honor, the comment is another lead that the officer followed. Because he thought it was threatening, he then had to investigate the residence of the defendants.
I see. So it also caused him to go to see Miss Klein.
Yes, Your Honor.
Right.
That is the relevance.
The objection is overruled. Please proceed.
What, if anything, of relevance did you find at the defendant's residence?
I found a flip phone plugged into the wall in the living room.
Did you investigate the phone any further?
Yes, Ken Holmes, the owner of the phone, gave me permission to look at it.
And what, if anything, did you find on it?
Well, he opened it to me and handed it to me without looking at it, and I found the actual false text tip sent at 9:08 p.m.
Now, officer, what, if anything else, did you do in your investigation?
I then interviewed Holmes, Patterson, and Klein separately.
And speaking of the defendant, Ms. Klein, could you identify her for the court?
Yes, she's sitting at the end of the defense counsel table wearing a plaid blazer.
Officer, you may be seated. One final question. What, if anything, did you learn from your interview with the defendant?
She denied sending the text tip, but admitted to using Cameron's phone through the night and sending the threatening comment.
Thank you, officer. No further questions, Your Honor.
Cross-examination?
Yes, Your Honor. May I inquire?
Yes.
Good evening, Officer Lopez.
Good evening, ma'am.
Now, Officer Lopez, you rode with Mr. Smith in the back of the ambulance to the hospital, didn't you?
Yes, that's correct.
And in the back of the ambulance, Mr. Smith showed you the comment that the Hayden account had posted, true?
Yes, ma'am.
And in the back of that ambulance, at this point in time, you hadn't interviewed Miss Klein, had you?
No, I had not.
You hadn't interviewed anybody besides Mr. Smith, true?
Yes, that's correct.
And then after interviewing Mr. Smith, you went to Miss Klein's apartment, correct?
Yes, to further investigate the false text tip and the threatening comment.
And when you got to the apartment, didn't Miss Klein voluntarily let you inside?
Yes, she did.
She also admitted to being an operator of the Hayden account
Yes, she did.
and to posting the comment.
Yes, ma'am, she did.
But she did not admit to sending the text tip, did she?
No, she did not.
She proclaimed her innocence, true?
True.
And then, at the apartment, you also interviewed Cameron Holmes, true?
Yes, along with Marlo Patterson.
Cameron Holmes told you that Cameron had no beef with Sawyer, correct?
Correct.
Objection, Your Honor. Hearsay?
May I be heard, Your Honor?
Yes, you may.
Your Honor, this is not being offered for the truth of the matter asserted, but merely to show that Mr. Holmes immediately turned on Mr. Smith when questioned.
In this case, what exception? Because otherwise, Your Honor, I believe that's still going to show the truth of the matter that Cameron had no beef with Sawyer.
Just let me unravel this. Ms. Klein testified, told the officer that Cameron had no beef. Perhaps you could rephrase your question.
Cameron told the officer that Cameron Holmes had no beef with Sawyer Smith, true?
Yes, that's true.
And your objection is hearsay?
Yes, Your Honor.
Sustained.
Move to strike.
Stricken.
Now, Officer Lopez, on the night of August 14th, you decided you didn't have enough information to arrest Miss Klein for false reporting.
Yes, the only reason why I arrested Miss Klein was because she admitted to sending the threatening comment.
That's right, you arrested her for criminal threat, didn't you?
Yes, that's correct, ma'am.
And later you charged her with false report, true?
Yes, after giving writing samples to a linguistics expert.
That's right, the only new evidence that you obtained after the night of August 14th was the opinion of Dr. Dakota Chung, correct?
Yes, that's correct, ma'am.
Thank you, I have no further questions, Your Honor.
Redirect?
No redirect, Your Honor. May this witness be excused?
Yes, officer, you may step down. You are excused. Next witness for the prosecution.
The people call Dr. Dakota Chung to the witness stand.
Dakota Chung to the stand.
Please raise your right hand. You solemnly affirm that the testimony you are about to give will faithfully and truthfully conform to the facts and rules of the mock trial prosecution? I do. Please be seated. Please state your full name, spelling the last for the record.
Dakota Chung, C-H-E-U-N-G.
Your Honor, before I begin, may I rearrange the exhibits?
Yes.
May I proceed?
You may.
Good afternoon, Dr. Chung.
Good afternoon.
Can you please introduce yourself for the court?
My name is Dr. Dakota Chung. I'm a forensic linguist and I've been a professor at the University of California for over 18 years. I received my PhD in linguistics from West California University.
And what experience do you have as a forensic linguist?
I have conducted over 100 independent studies on author identification in various formats. I've also served as an expert witness in 40 prior cases.
Now, what were you asked to do in connection with this case?
In this case, I was asked to identify the author of the anonymous false text attempt.
Were you able to do so?
Yes, I was.
How did you do so?
I used a stylistic approach as described by highly respected British forensic linguist Dr. Tim Grant, called pairwise distinctiveness. Using this approach, I analyzed over 76 of the defendant's social media posts and over 92 of Cameron Holmes' social media posts that the police gathered and gave to me.
Your Honor, may the witness approach the exhibits?
Yes.
Dr. Chung, do you recognize Exhibit C?
Yes, I do. I created it.
Can you please explain the exhibit you created?
In Table 1, I listed the features I found prevalent in the defendant Reagan Klein's writings. In Table 2, I listed the features I found in Cameron Holmes' writings. And in Table 3, it combines the previous two tables along with information about the false tip.
Can you please elaborate Table 3 for me?
Table 3 is the real meat of my analysis. In Column 1, I listed the features I found in Klein and Holmes' writings. In Column 2, I determined and listed the amount of times these features were present in the false tip. And in Columns 3 and 4, I listed the amount of times these features were found in Klein and Holmes' writings.
Now, Dr. Chung, I noticed that some of the features in Table 3 are missing within the false text tip. What, if anything, does this tell you?
The most interesting feature missing from the false tip is misspellings. Holmes has an unfortunate tendency to misspell, over a dozen times in his social media posts, while Klein hardly ever misspells. As you can see, there are no misspellings in the lengthy false tip. This strongly indicates Klein to be the author of the tip.
So, Dr. Chung, what does Exhibit C prove?
Exhibit C proves how much of the Klein's writing is in the false tip. Over five of the features in Klein's tip, multiple typographic exclamations, use of quotation marks, use of ellipses, use of commas, and use of 8-letter or longer adjectives are found in the false tip.
Thank you for your observation. You may be seated. Now, are you familiar with Dr. Williams' involvement in this case?
Yes, I am. I reviewed her reports.
And do you agree or disagree with her conclusion?
I strongly disagree. Unlike the approach I used, Dr. Williams' approach relies on distinctive vocabulary choice, which is a conscious choice, while these features are more based out of habit.
Now, my final question for you. In your expert opinion, who is the author of the false text tip?
In my expert opinion, I can say to a scientific certainty that it was the defendant, Reagan Klein, who wrote the false tip.
Your Honor, the people move Exhibit C into evidence. I'm sorry?
Any objection?
None, Your Honor.
Exhibit C is received.
Dr. Chung, I have no further questions for you.
Cross-examination.
Yes, Your Honor. May I inquire?
Yes.
Good evening, Dr. Chung.
Good evening.
Now, you believe that Miss Klein is probably the author of the text-to-tip message, correct?
I do believe that, yes.
And you focused on the features of the tip, right?
Yes, because they're well suited.
And not the vocabulary of the tip?
No, I did not focus on that.
But Dr. Williams focused on vocabulary in addition to the features, correct?
No, she did not focus on the features. She simply looked
She
at
took
what
into account the features as well as the vocabulary in her analyses. Is that not true?
She focused on the features. She overlooked she looked at what I analyzed, yes.
And she also studied the vocabulary of the message, correct?
Yes.
Thank you. Now, in the 76 social media posts that you analyzed, Miss Klein never once uses the word really, correct?
No.
And she never once uses the word please either, right?
No.
But both of these words are present in the text-to-tip message, correct?
Yes.
Really is shortened to RLLY, correct?
Yes.
And please is shortened to PLZ, right?
Correct.
Now, between Mr. Holmes and Miss Klein, who shortens their words?
Mr. Holmes.
That's right. Mr. Holmes also uses whole word letter homophone substitution, right?
Yes, that is correct.
And that's present in the text-to-tip message, is it not?
Yes, it is.
Mr. Holmes also uses whole word number homophone substitution, correct?
Yes, that is correct.
And that's also very present in the text-to-tip message, right?
Yes, it is present.
Finally, you cannot be completely certain whether or not Miss Klein was the author of the text-to-tip message, right?
I believe I can say to it in my expert
But can you be
opinion.
completely certain of who wrote the text-to-tip message?
I can be scientifically certain.
You can. But in your witness statement, you stated, I believe that Miss Klein more likely than not wrote the text-to-tip message.
Yes.
Is that right?
This falls in with scientifically certain.
And does more likely than not mean completely certain?
It does not mean absolutely certain, but it could mean completely certain, yes.
Thank you, Dr. Chung. Your Honor, I have no further questions.
Redirect.
Yes. Now, may I proceed?
Yes, you may.
Dr. Chung, why did you choose pairwise distinctiveness as your method?
I chose...
Objection, Your Honor. This question is outside the scope of cross-examination.
May I be heard? I believe that opposing counsel brought up the fact of Dr. Williams' method and contradicted Dr. Chung's method. Therefore, I would like to ask her why she chose this method.
Do you wish to be heard further?
Yes, Your Honor. The defense's cross-examination did not inquire about which method of analysis she chose and why she chose that method.
But the cross-examination did focus on the different methods, so the objection is overruled.
Would you like me to repeat my question, Dr. Chung?
No, I remember the question. I chose pairwise distinctiveness because it is specifically suited for shorter messages like social media posts, which is most of what me and Dr. Williams analyzed.
Thank you, Dr. Chung. I have no further questions, Your Honor. May this witness be excused?
Yes, thank you, Doctor. You may step down. You're excused. I believe that concludes the prosecution's case.
Yes, Your Honor, the people rest.
Moving to the defense. Does the defense wish to call its first witness?
Yes, Your Honor. The defense calls Blake Williams to the stand.
Blake Williams to the stand. Please raise your right hand. You solemnly affirm that the testimony you are about to give will faithfully and truthfully conform to the facts and rules of the mock trial competition?
I do.
Please be seated. Please state your full name, spelling the last for the record.
Dr. Blake Williams, W-I-L-L-I-A-M-S.
May I inquire?
Yes, you may.
Good evening, Dr. Williams.
Good afternoon, Mr. Suh.
What is your occupation?
I am a professor of linguistics at the University of California, where I've been for the past 24 years.
Have you served as an expert witness before?
Yes, I have, 70 times.
What are your qualifications?
Well, I have a PhD in linguistics from Eastern California University, and I have covered over 120 independent studies on author identification in various forms.
How are you involved in the case at bar?
I examined the false textative report, the posts made by the Hayden Carlton account, 76 social media posts made by Ms. Reagan Klein, and 92 social media posts made by Mr. Cameron Holmes.
How did you analyze these messages?
I used a time-tested stylistic approach, following the commonly used method of identifying consistent and distinct vocabulary choices, as well as opposing features present in the writings.
Your Honor, may I rearrange the exhibits to Exhibit D?
You may.
Dr. Williams, do you recognize Exhibit D?
Yes, I do.
What is it?
This is a chart that I created of distinctive vocabulary choices.
Is it a fair and accurate representation of your analyses?
Yes, it is.
Your Honor, may Dr. Williams approach Exhibit D?
Yes, you may.
Using the exhibit, please explain Ms. Klein's style of writing.
Ms. Klein has an affinity for longer, more complicated words. She tends to include descriptions with the word heart. She likes to focus on consequences, as well as value, and she frequently uses the I figure expression.
What about Mr. Holmes' style?
Continuing down the chart, Mr. Holmes likes to use the words really and please. He has his own unique spelling preferences for both those words. He also talks about what someone deserves, and he likes to use metaphors in his writings.
Based on your analyses, who is more likely to have been the author of the text-to-tip message?
Cameron Holmes.
Why do you say that Cameron Holmes wrote the message?
Well, comparing the features here to the text-to-tip, we have the elements from Cameron Holmes of what someone deserves, as well as the words really and please actually with Cameron's unique spelling preferences. emphasis. On the other hand, the parts with Ms. Klein's vocabulary choices, such as the oddly phrased pointed gun at Sawyer's heart, do not match Ms. Klein's normal writing style, but instead sound like someone trying to intentionally sound like her, possibly friend her.
You may resume your seat, Dr. Williams.
Thank you.
In your expert opinion, did Ms. Klein write the text-to-tip message?
No, she did not.
Thank you, Your Honor. I have no further questions.
Cross-examination.
Yes, Your Honor. Before I begin, may I rearrange the exhibits?
Yes.
Thank you.
You may.
Good afternoon, Dr. Williams.
Good afternoon, Ms. Lopez.
Are you familiar with Dr. Chung's involvement in this case?
Yes, I am.
And are you familiar with Exhibit C?
Of course.
May I approach the exhibits, Your Honor?
You may.
Now, turning your attention to Exhibit C, Dr. Chung shows us that Cameron Holmes has a tendency to misspell words, correct?
Dr. Chung, sorry.
Dr. Chung shows us that in Table 3, Cameron Holmes has a tendency to misspell words, correct?
Oh, I wouldn't necessarily call it a tendency. 14 out of 92.
However, Cameron Holmes does misspell words, correct?
14 times out of 92 posts.
And there are actually 0 misspellings within the false text tip, correct?
Yes.
And the defendant tends to use 8-letter or longer adjectives, correct?
The defendant has used 8-letter or longer adjectives, yes.
And there are 2 of these present within the false text tip?
Yes.
Now, turning your attention to Exhibit D, Exhibit B,
Yes.
you solely focused on distinctive vocabulary, correct?
No, I did not solely focus on distinctive vocabulary.
But in Exhibit B, the only thing mentioned are distinctive vocabulary, correct?
Oh yes, Exhibit D focuses solely on distinctive vocabulary, but I didn't.
Okay, now turning your attention to the word heart. The defendant tends to use variations of the word heart, correct?
Yes.
And the word heart is present within the false text tip, isn't that right?
It is.
And in addition to the word heart, the defendant tends to use variations of the word value, correct?
Yes.
And valuables is in fact included within the false text tip, correct?
Yes.
And in addition to these 2 words, the expression I figure is commonly used by the defendant.
21 times out of 76 posts.
And this expression figure was included within the false text tip, correct?
Yes, it was.
Thank you, Dr. Williams. And now, Dr. Williams, you're aware that Dr. Chung used pairwise distinctiveness, correct?
Yes, I am.
And you're aware that pairwise distinctiveness is well suited for social media posts, correct?
Yes, just as much as mine.
I'm sorry, I didn't ask you about yours. I only focused on Dr. Chung's non-responsive objection. Move to strike everything after yes.
Yes, the objection is sustained and everything after the word yes is stricken.
Now, Dr. Williams, you in fact agree with Dr. Chung that the writing features within Exhibit C are prevalent within the false text tip, correct?
All of the writing features in Exhibit C?
Yes.
No, just the ones that are just the ones distinctive of Reagan's writing.
Correct. You agree. Would you like me to repeat the question?
Please.
Okay. You agree with Dr. Chung that the writing features within Exhibit C are prevalent within the false text tip? Yes or no, please?
Not necessarily.
You gave a witness statement, didn't you?
Yes.
And turning your attention to page 45, line 42 through 45, you said the examination of the features exhibits reveals that those features that are generally distinctive of Reagan's writing are much more prevalent in the tip than those generally distinctive of Cameron's writing, correct?
Yes, the features distinctive of Reagan's writing.
Now, my final question for you. You cannot be 100% sure that Cameron Holmes wrote the false text tip, correct?
Of course not. It could have been anyone.
Thank you, Dr. Williams. I have no further questions for you.
Reiterate.
Yes, Your Honor. Dr. Williams, what method of analysis did you use?
I used a time-tested stylistic approach, the traditional one, which follows the commonly used method of identifying consistent and distinct vocabulary choices as well as opposing features.
Objection, Your Honor. This question was asked and answered in the direct.
May I hear Your Honor?
Yes.
This question was not asked and answered.
I believe opposing counsel asked Dr. Williams about her method.
I'm going to allow the question in my discretion in light of the exploration of this witness's methods that occurred under cross-examination. Overruled.
Thank you, Your Honor. Dr. Williams, how do you explain the words distinctive to Ms. Klein's style of writing that are present in the text-to-tip message?
Well, the words distinctive of Ms. Klein's writings do appear in the text-to-tip message, but they appear in ways that do not match her natural writing style, and they sound like someone intentionally throwing them in, trying to sound like Reagan.
Thank you, Dr. Williams. Your Honor, I have no further questions. May Dr. Williams be excused?
Yes, Dr. Williams, you are excused and you may step down.
Your Honor, at this time, the defense would like to move Exhibit D into exhibits.
Any objection?
No objections, Your Honor.
Exhibit D is received in evidence. Next witness for the defense.
Defense calls Ms. Patterson to the stand.
Marlo Patterson to the stand. Please raise your right hand. Do you solemnly affirm that the testimony you are about to give will faithfully and truthfully conform to the facts and rules of the mock prosecution? I do. Please be seated. Please state your full name, spelling the last for the record.
Marlo Patterson, Patterson.
Your Honor, before I proceed with the questioning, may I rearrange the exhibits?
Yes, you may.
Your Honor, may I proceed?
You may.
Good afternoon, Ms. Patterson.
Good afternoon.
Do you know Reagan Klein?
Yes, she's a very good friend of mine.
How would you describe your relationship with Reagan?
Well, we both go to the same college, and we work together at Hennessy's every summer. We've gotten a lot closer these past few months, ever since Sawyer and Reagan stopped hanging out.
Where were you on the nights of August 14th?
I was over at Reagan's apartment with Reagan and Cameron.
What were you doing at her apartment that night?
We just hung out, and I ordered pizza from my favorite pizza place, Joe's Pizza Shack. At 8:57, my sister called. We talked for about 20 minutes.
What happened while you were on the phone call with your sister?
I got a notification at 9 o'clock that our pizza had arrived.
Who went downstairs to pick up the pizza?
I asked Cameron to get it.
Your Honor, may the witness approach the exhibits?
Yes, you may.
Ms. Patterson, do you recognize this?
I do.
What is it?
It's my Yum Yum delivery order history.
Is it a fair and accurate representation of your Yum Yum delivery history log?
Yes.
According to the exhibit, at what time was the pizza delivered?
9:02 p.m.
Do you normally receive these notifications from your Yum Yum delivery app?
I do, yes.
Have you used this delivery service before?
Oh yeah, plenty of times. I've always wanted to be very reliable and convenient. Its entries are generated automatically.
Your Honor, may the witness rearrange the exhibit so that Exhibit E appears on the front?
Exhibit E.
Yes.
Yes, you may.
Ms. Patterson, do you recognize this?
Yes.
What is it?
It's the layout of Reagan's apartment.
Is it an accurate layout of Reagan's apartment?
Yeah, it is.
Now, using the exhibit, can you please point out your location at the time of 9:08?
I was standing in this corner of the room next to the TV.
And where was the phone that night?
It was lying on the side table, charging.
From where you were standing, did you see Reagan using Cameron's phone that night?
No, I didn't see Reagan with Cameron's phone at all during the night.
Your Honor, may Ms. Patterson resume her seat?
Yes, you may, Ms. Patterson.
Ms. Patterson, what happened after you got off the phone with your sister?
Officer Keegan Lopez arrived at the apartment and asked me if I had seen anyone using the phone.
And have you seen anyone using the phone?
Yes, Cameron had been checking it regularly throughout the night.
Ms. Patterson, how are you acquainted with Cameron Holmes?
He and I work at Hennessy's together.
Have you noticed any change in Cameron's behavior lately?
Yes, he had been acting pretty strange and territorial lately. He even told me that he wanted to get Reagan out of the picture.
Objection, Your Honor. Improper opinion testimony as to strange.
Your Honor, may I return?
Yes.
This opinion is admissible because it goes to show Mr. Holmes' state of emotion.
Well, it's the objection. The objection is an objection based on opinion.
Yes.
Your response responds to an objection based on hearsay. Is this an improper opinion? Her description of his behavior is strange?
No, Your Honor. This
Why
opinion
not?
is helpful to a clear understanding of the testimony.
And she's familiar with Mr. Holmes?
Yes, she was in a position to formulate this opinion.
Do you wish to be heard further?
I withdraw my objection, Your Honor.
Thank you. The objection is overruled.
Ms. Patterson, since when did you start noticing the strange behavior from Cameron?
Ever since Reagan and I started getting closer.
Thank you. No further questions, Your Honor.
Cross-examination?
Yes, Your Honor. May I proceed?
You may.
Good afternoon, Ms. Patterson.
Good afternoon.
You say that you became closer friends with the defendant after Sawyer Smith dropped her as a friend, correct?
Yes, that's right.
And you noted that it was lame for someone to do that to someone else, correct?
It was, yes.
Now, you participated in the catfishing scheme, correct?
Yes, I did.
And you worked very closely with Reagan, correct?
I did, yes.
And you claim that the catfishing account was both fun and hilarious to you, correct?
At the time it was.
And after you had had your fun, you decided to stand up Sawyer Smith, correct?
Yes.
And you even wrote the caption and took the picture of him at the restaurant, correct?
Yes.
All right. Now, I'd like to direct your attention to the night of August 14th. You were at the residence of the defendants on this night, correct?
I was.
And you were on the phone with your sister, correct?
That's right.
From 8:57 for about 20 minutes.
Yes, that sounds right.
Your Honor, may I approach the exhibits?
Yes, you may.
Now, Miss Patterson, while you were on the phone on that night, you were standing in court, correct?
Yes.
And Reagan was over here at the table?
Yes.
And this is where Cameron Holmes' phone was, correct?
Yes.
So who was closest to the phone?
Reagan was.
Thank you. Now, Miss Patterson, on that night, you claim that you never saw Miss Klein touch the phone, correct?
That's right.
But you note that she commonly checks the nearest phone for the time, correct?
Yes. I would have noticed if it had taken longer.
All right, and you note that you didn't see her on the phone for more than a few minutes, correct?
Sorry, can you repeat?
You didn't see her on the phone for more than a few minutes, correct?
Yes.
Not even at 9:11 by any chance.
That's right.
But you do admit that while on the phone that night, you were somewhat in outer space and not all there. Yes or no, please?
Yes, but I could see fine.
Thank you. One final question, Ms. Patterson. You would say that yourself and the defendant are pretty close, correct?
We are, yes.
Thank you. No further questions, Your Honor.
Redirect?
Yes, Your Honor. Ms. Patterson, besides you and Reagan, who else participated in the catfishing incident?
Cameron?
Now, Ms. Patterson, did your phone call with your sister obstruct your line of vision?
No, it didn't.
What does Reagan normally do on whoever's phone is closest to her?
Objection, Your Honor, outside the scope of cross-examination.
Your Honor, may I be heard?
Yes.
This falls within the realm of cross-examination as the opposing counsel has asked Ms. Patterson if Reagan was closest to the phone.
Yes, there was also a question concerning her habit with regard to other people's phones, so the objection is overruled.
Ms. Patterson, have you answered the question?
Could you repeat the question?
What does Reagan Klein normally do on whoever's phone is closest to her?
Oh, she quickly checks the time.
Now, Ms. Patterson, would you have noticed if Reagan Klein had been lurking around the phone?
Yes, I would have.
Thank you, Your Honor. May Exhibit B be moved into evidence?
Is there any objection?
Yes, Your Honor. Objection as to hearsay.
As to Exhibit
B.
E?
B.
B. Which, remind me, I thought B had already been received in evidence.
No, Your Honor, I believe Exhibit B is the screenshot of Marlo Patterson's delivery history, which had not been registered.
That objection is overruled as a result of the stipulation.
Thank you, Your Honor.
You may step down and you are excused. Next witness for the defense.
Defense calls Sam Colossian to the stand.
Sam Colossian to the stand.
May I inquire as to how much time the defense has for direct examination?
Yes.
Currently, the defense has 7 minutes and 26 seconds. As for the prosecution, they have 4 minutes and 35 seconds.
Thank you.
Please raise your right hand. Do you solemnly affirm that the testimony you are about to give will faithfully and truthfully conform to the facts and rules of the mock trial competition?
I do.
Please be seated. Please state your full name, spelling your last for the record.
Sam Colostian. Kolosstian.
Good afternoon, Mr. Colossian.
Good afternoon, Mr. Saylor.
Can you please state your occupation for the court?
I am the proud owner of Hennessy's, the finest restaurant in all of East Flamingo.
How do you know Reagan Klein?
Oh, she was a former employee of mine.
How would you describe Reagan?
Oh, she's a pleasure for everyone to be around. Sure, sometimes she made mistakes. She wasn't perfect, but she always looked out for others.
What kind of mistakes did she make?
Well, I believe a couple months back, she broke my beloved baker's pride oven.
How did you find out that Reagan had broken your beloved pride oven?
Well, I believe on August 14th it was that Sawyer Smith came in and told me Reagan had broken my oven. So when Reagan clocked in for work, I fired her, telling her she'd be hearing from my lawyers about the $34,000 oven. Though I was never really going to sue her. The insurance covered everything.
Have you learned any new information concerning the oven since the time of the fire?
Yes. Though Sawyer Smith told me she had just found out Reagan broke my oven, I found out she knew about the whole incident for 8 months.
Mr. Colossian, do you recall what you and your employees were doing a few days before August 14th?
Yes, I believe the morning before the restaurant opened, all my employees and I were watching the news story. I believe it was about swatting.
Did you catch a reaction from Reagan after she watched that SWAT news story?
Objection, Your Honor. Relevance as to the testimony about the swatting incident?
Your Honor, may I be heard?
Yes.
Ms. Klein's reaction to the SWAT news story goes to show that she possesses a character inconsistent with the act of swatting.
Just repeat, would you repeat what you just said?
Yes, Mr. Colossian will testify to Ms. Klein's reaction to the SWAT news story and thus provide evidence as to how and why she possesses a character inconsistent with the act of swatting.
Your Honor, the defense is only allowed to bring in certain character evidence if it goes to disprove a count. And I believe the only one count remaining for the defendant is count 1, false report of an emergency, not swatting.
The objection is overruled.
Mr. Klein, did you catch a reaction from Reagan after she watched that SWAT news story?
Yes, I did. She looked visibly upset by what the perpetrator did, even commenting on how horrible it was that someone got shot.
Objection, Your Honor, hearsay as to what the defendant said.
Any response?
Your Honor, may I be heard? This is a hearsay exception. This goes to show that it goes to show Ms. Klein's state of mind.
As to, and further supports the way in which she reacted to a swatting incident?
Yes, Your Honor.
Do you wish to be heard further?
No, Your Honor, but objection, improper opinion as to looked so upset.
Overruled.
Mr. Colossian, in the years you have worked with Ms. Klein, have you ever seen a customer of yours at risk of suffering severe bodily harm?
I can recall one incident.
Can you please explain this case to the court?
Well, one of my newer trained employees was carrying a platter of hot plates, fresh from the oven, to a corner table, but As she was going there, she dropped the hot plates, and it almost landed on the baby, but luckily Reagan was there to catch the hot plates, saving the baby, but also getting second-degree burns in the process.
Objection, Your Honor, inadmissible character evidence. May I hear?
Yes.
The defense is only allowed to bring in character evidence in the form of opinion testimony or reputation, not specific acts.
Your Honor, may you the defendant is testifying to the defendant's own character. This falls under one of the exceptions to...
But it is a testimony of a specific act rather than reputation. Is that not correct?
This is not being offered to show that she necessarily acted in accordance with this particular action, rather that she possesses a character inconsistent.
Do you wish to respond?
I re-raise my argument, Your Honor. The defense is only allowed to bring it in the form of opinion testimony or an act of reputation, not this one specific act.
Yes, the objection is sustained.
Move to strike this witness's testimony about the incident.
The answer concerning the incident with regard to hot plates is stricken.
Thank you.
Now, Mr. Closian, have you ever seen Reagan take revenge on someone?
Well, in all the 6 years I've known her, not once.
Thank you. No further questions, Your Honor.
Cross-examination.
Yes, Your Honor. Good evening, Mr. Clostian.
Good afternoon, Ms. Donovan.
Excuse me, afternoon. Let's talk a little bit about the defendant's character. You fired the defendant from your workplace, isn't that right?
Yes, I did.
You fired them for breaking your $34,000 oven, isn't that right?
I did fire her for breaking my oven, yes.
Right, and lying to you about it for over 7 months, isn't that right?
I believe she kept that information for me for about 7.5 months, yes.
That's a yes.
That is a yes.
Okay. And after you fired the defendant, you then told them that your lawyer would be contacting them about the $34,000 lawsuit, isn't that right?
Oh, yes, I was just so furious at the moment that I slipped out and said such things, though I was never really going to sue her.
I'm sorry, is that a yes?
Yes, I was never really going to sue her.
Alright, and after you told the defendant this, you then witnessed the defendant directly shoot a glance at Mr. Smith from across the room.
Yes, I believe she did look at that direction.
Alright, thank you, Mr. Clostian. No further questions, Your Honor.
Redirect.
Yes, Your Honor. Mr. Closian, at the time of the firing, were you aware of the fact that Sawyer Smith had also known about the long-kept secret?
No, I had not known that Sawyer was also lying to me at that time.
Now, Mr. Closian, were you seriously intending to file a lawsuit against this client?
No, once again, my insurance covered everything, and in 2 weeks my oven was replaced. Good as new.
Thank you, Mr. Closian. No further questions, Your Honor.
Thank you, Mr. Closian. You may step down and you are excused. Next witness for the defense.
Yes, Your Honor. The defense calls Reagan Klein to the stand.
Reagan Klein to the stand. Please raise your right hand. You solemnly affirm that the testimony you are about to give will faithfully and truthfully conform to the facts and rules of the mock trial petition? Please be seated. Please state your full name, spelling the last for the record.
Reagan Klein, K-L-E-I-N.
Okay, Clark.
You may.
Good afternoon, Ms. Klein.
Good afternoon.
Are you familiar with Sawyer Smith?
Yes, I am. We've been close friends until he decided to end our friendship.
What did you do after Mr. Smith ended your friendship?
Since Sawyer and I weren't hanging out any longer, I became friends with Marlo and Cameron from my work.
Did the three of you ever interact with Mr. Smith?
Sawyer's bragging had gotten quite annoying, so Marlo, Cameron, and I created a fake account under the name Hayden Carlton.
Did you ever post anything on this account without first running it through Ms. Patterson and Mr. Holmes?
No, almost everything went through Marlo and Cameron before it was posted.
Directing your attention to August 14th, what happened when you went to work?
I had gone into work as usual, and I was so confused and shocked when my boss, Sam, fired me and mentioned the oven I had accidentally broken.
Ms. Klein, why hadn't you told Mr. Klostein about the oven?
At the time, Sawyer and I were close friends, and I had gone to him for advice about the situation, and I completely trusted him when he told me that I didn't have to say anything.
Objection, Your Honor. Hearsay as to Sawyer Smith's testimony.
Do you wish to be heard?
Yes, this statement that Ms. Klein is testifying to is not being used to show the truth of the matter, but to show the motive behind, or the, why she... Wait, hearsay as to what? I'm sorry?
Do you wish the prosecution to clarify its
Yes.
objection? Would you
Hearsay
clarify your objection?
Of course. Hearsay as to what Sawyer Smith told the defendant.
Yes. Why is Mr. Smith's statement of advice to Ms. Klein not hearsay?
Well, Your Honor, it's not being used to show the truth of the matter, but rather it is relevant character evidence showing that Mr. Smith has an untrustworthy character.
The objection is overruled. Sorry, the objection is sustained. Please proceed.
Before that, move to strike the hearsay testimony.
Yes, that testimony is stricken.
Ms. Klein, what did you do that night?
I went home, and I had my friends Marlo and Cameron over to hang out and have pizza that night.
Who ordered the pizza?
Marlo ordered the pizza.
Didn't Mr. Holmes order the pizza? I mean, who went to get the pizza? I'm sorry.
Cameron did.
And when did Mr. Holmes come back up?
5 minutes later about.
Did Mr. Holmes do anything when he came back up?
He had come back up with the pizza and went directly to his phone and opened it.
Ms. Klein, did you yourself touch Mr. Holmes' phone that night?
I did look at it once to check the time.
And at what time was that?
9:11 p.m.
Reagan Klein, did you send the text-to-tip message?
No, I did not.
Thank you, Your Honor. I have no further questions.
Cross-examination.
Yes, Your Honor. May I proceed?
You may.
Good afternoon, Miss Klein.
Good afternoon.
You and Sawyer Smith used to be good friends, true?
We were best friends, yeah.
That is until he dropped you as a friend, correct?
Correct.
So in retaliation, you decided to catfish him, correct?
Yes, it was a foolish
Thank you,
thing
Miss
to do.
Klein. And out of the 3 users, you used the catfishing count the most, correct?
Probably the most.
All right. And after you assumed that catfishing had no negative effect on Mr. Smith, you then began a continual onslaught of mean words, correct? In your own words, you'd say that's what you did. Yes?
That is correct.
All right. But somehow Sawyer Smith discovered you were behind the catfishing, correct?
Yes.
Because he reported to Sam that you had ruined your Baker's Pride oven last New Year's Eve, correct?
Yes.
And as a result, you got fired, correct?
That is correct.
You were also told that you were going to be sued for $34,000, correct?
That is exactly what I was told, yes.
And Ms. Klein, you're a college student, correct?
I am, yes.
And you have student loans?
Yes, I do.
And the fact that Sawyer would do this to you made you furious, correct?
It confused me, and yes, I was
You would even go as
upset.
far as to say you were enraged?
Yeah.
You even say that metaphorically you were seeing red, correct?
Yes.
You would even go as far as to say you lost your mind?
Yes, I did.
And that in your haze you posted something nasty on Sawyer Smith's napkin page, correct?
That's correct, yeah.
Are you all right, Ms. Klein?
I am fine, thank you.
Okay. And you would even go as far as to say that it was aggressive, correct?
It was, yes.
Now, referring to that comment, you told Sawyer Smith you deserve to die. I'm going to get you for this, correct?
I did, yeah.
And you also told him that when you're dead, no one will even miss you, you monstrous slime of a person, correct?
I said that, yes.
And finally, watch your back, Sawyer. I'm coming to get you. You said this. Yes or no, please?
Yes.
Thank you, Ms. Klein. Now, I'd like to direct your attention to the night of August 14th, You say the camera was downstairs for less than 5 minutes, correct?
About or less, yes.
Alright, but there's no clock in your living room, correct?
No, there's not.
Therefore, saying he was downstairs for less than 5 minutes was purely an estimation. Yes or no?
Yes, I believe I have a general idea.
Was it an estimate, Ms. Klein?
It was an estimate, yes.
Thank you. And one final thing, you were on Karen Holmes' phone on the night of August 14th.
To check the time, yes.
At 9/11?
At 9/11, yes.
Thank you. No further questions, Your Honor.
Redirect.
Yes, Your Honor. Ms. Klein, did you mean any physical harm to Mr. Smith through any of your comments?
No, I would never hurt anyone, let alone someone who was my best friend of so long.
On the night of August 14th, was Marlo in the same room as you?
Yes, she was.
And did she ever leave that room?
No, she did not.
Thank you, Ms. Klein. Your Honor, I have no further questions. May Ms. Klein be excused?
Oh, she can't be excused, but she may step down and take her place back at the council table. I assume that the defense rests this time?
Yes, Your Honor. At this time, the defense rests.
Right, then we'll move on to closing argument by the prosecution.
Yes, Your Honor. May I proceed?
You may.
Heaven has no rage, like love to hatred turned, nor hell of fury like a best friend scorn. This wise quote penned in 1697 by playwright and poet William Congreve perfectly summarized the case that you just witnessed, Your Honor. It's the backbone of our story and the structure of our narrative. Reagan Klein and Sawyer Smith were best friends for 8 entire years. They were best friends until their friendship abruptly turned south for petty reasons. Sawyer Smith decided to pursue a career in social media and surprisingly found success in their endeavors. They then shared their victories with their coworkers. That is, until one of those coworkers had had enough. Reagan Klein, in retaliation, tried to catfish their now friend-turned-foe. But not only did their plan not work, it in fact backfired. Sawyer Smith ended up gaining followers. Angering the defendant, they then began a continual onslaught of mean words. They began to publicly humiliate, harass, and embarrass Sawyer Smith. But still it didn't work, and still it backfired. Because Sawyer Smith then struck back by revealing a long-kept secret that resulted in the firing of the defendant. But not just causing the defendant to lose their job, Your Honor. A $34,000 lawsuit. The defendant became furious. They became enraged. They were seeing red and they lost their mind. In their haze, they posted on Sawyer Smith's now page, "You deserve to die. Going to get you for this. Just you wait, I hate you. When you're dead, no one will even miss you, you monstrous slime of a person. You think you can stick me with a $34,000 lawsuit? Just get away with it? Watch your back, Sawyer. I'm coming to get you." An unconditional, unequivocal, and immediate threat. Your Honor, the defendant threatened to kill Sawyer Smith. Thankfully, this was not the case. But the defendant, clearly not in their right mind and clearly upset, attempted to carry out their threat the only way they knew how, by trying to swat their enemy. That brings us directly to count 1, a false report of emergency in California Penal Code 148.3. The first of 6 elements required to prove this count is that the defendant reported or caused a report to be made. Tonight, you heard from qualified expert witness Dr. Dakota Chung, who determined through a reliable process that due to the similarities between the writings of the defendant and the writings in the text tip, the defendant was in fact the undisputed author of the text tip. As to element 2, the defendant reported to a city, county, and or state department a false emergency was provided by SWAT officer Keegan Lopez when he testified about his team receiving the text tip on August 14. As to element 3, the defendant reported a true emergency exists. Can clearly be seen in Exhibit A, where the defendant lied about there being a very dangerous hostage situation at the residence of Sawyer Smith. As to element 5, the defendant, knowing that their report could cause death or grievous bodily injury. Now, this was proven during the cross-examination of Sam Closton, where Mr. Closton testified that the defendant was present and engaged during a news program about swatting. At a swatting incident in which someone was shot. Your Honor, thankfully in this case, no one was shot. No one was killed. But Sawyer Smith broke their leg, fulfilling the 6th and final element of count 1 beyond a reasonable doubt. Your Honor, the people of the state of California have proven all the elements of count 1 beyond a reasonable doubt. But, Your Honor, let's look at the timeline in our case. Let's look at the means, the motive, and the opportunity of the defendant to have sent the false report of an emergency. Let's begin with the events of August 14th. Before August 14th, the defendant had catfished Sawyer Smith. The catfishing then escalated to humiliation and harassment. Your Honor, though it has been brought up that there may not have been a past animosity between the defendant and Sawyer Smith, it was, in a sense, a one-sided history of animosity, because the defendant repeatedly became upset as Sawyer Smith didn't react to the catfishing, and they didn't react to the harassment, they didn't react to the humiliation. Therefore, the anger in the defendant began to build up, and on the day of August 14th, their anger reached its peak. After being fired from their job, after being threatened with a $34,000 lawsuit, after realizing they wouldn't be able to pay off their student loans, that they had lost one of their only jobs, Reagan Klein snapped. Your Honor, on August 14th, they sent the threat that said, "You deserve to die," and that they were going to get them. Later that evening, they were at their house with Marlo Patterson, a very close friend, and Cameron Holmes. At 8:57, Marlo Patterson was on a phone call. At 9:02, Cameron Holmes went downstairs, leaving Marlo Patterson and Reagan Klein to be the only 2 people in the apartment. Your Honor, according to Cameron Holmes' testimony, he was downstairs for 10 full minutes, leaving the defendant 10 full minutes to write the text tip in question. Your Honor, even if you don't believe that they had this time, let's look at the timeline after 9:08. At 9:08, the text tip was sent. At 9:11, the defendant was on the phone. Later that evening, during Officer Keegan Lopez's investigation, Cameron Holmes handed him the phone without looking at it, and there was the text tip on the screen. Your Honor, if you believe the defendant's testimony that they were on the phone at 9:11, you must believe that they saw the text tip that was on the screen. Why didn't they report it? Why didn't they say anything to Cameron?
Thank you, counsel. Closing argument for the defense.
Yes, Your Honor. Your Honor, may I have permission to approach the exhibits during my closing argument?
You do have permission to do so.
And may I request a time check as to the time remaining?
Yes.
The defense currently has 6 minutes and 27 seconds.
Thank you.
Please proceed.
Thank you. Your Honor, my client is not perfect. She rationally insulted Sawyer Smith and catfished him on social media through chatting and commenting. But Miss Reagan Klein is not guilty of a false report of an emergency. Your Honor, actions speak louder than words, and Miss Klein's actions show that she has a heart of gold and would never harm anyone. Miss Klein's impulsive words on social media do not reflect her true character. Today, the prosecution must prove beyond a reasonable doubt that Miss Klein is guilty of a false report of an emergency. However, Miss Klein's actions and the evidence you heard today point to the contrary. The prosecution has failed to prove all 6 elements beyond a reasonable doubt. But today, we're going to focus on the main element of did Reagan Klein send the tip? Your Honor, to prove this, they must show that Miss Reagan Klein was the only one with the means, the motive, and the opportunity to send the false tip. However, they cannot prove this beyond a reasonable doubt because there were others in the apartment the night the tip was sent, namely Cameron Holmes, with just as much means, motive, and opportunity. First, Miss Klein was not the only one with the means to send the tip. The text-to-tip was sent on the night of August 14th from Mr. Holmes' flip phone. And where was Mr. Holmes' phone the entire night? It was lying on a table, charging, out in the open where anyone in the apartment could have picked it up and sent the false tip. And you heard today from Miss Patterson that Cameron Holmes was touching the phone multiple times throughout the night. Second, Miss Klein was not the one with enough motive to send the false tip. Your Honor, Miss Klein was best friends with Mr. Smith for 8 years, and Miss Klein would never hurt anyone. You heard today about a swatting incident, and when Miss Klein saw that someone could get shot as the result of swatting, Miss Klein was horrified. However, the other 2 employees who also saw the news story and were both in the apartment the night the tip was sent were 2 people who were fed up with Mr. Smith's incessant bragging and were even willing to catfish him. These 2 people, not Miss Klein, had the motive to send a false report. Moreover, one of these 2 people, Mr. Cameron Holmes, even had the motive to frame Miss Reagan Klein. You heard today that Mr. Holmes was jealous of Miss Klein and Miss Patterson's friendship. Mr. Holmes felt excluded. Mr. Holmes wanted Miss Patterson to himself. Mr. Holmes thought that Miss Klein was a jerk. And just a few hours before the swatting incident, Mr. Holmes overheard Miss Klein complaining about him. Mr. Holmes wanted Miss Klein out of the picture. And to frame Miss Klein and have her arrested for false report would do just that. Finally, the opportunity. Your Honor, there were 3 people in the apartment the night the tip was sent. 2 people besides Miss Klein with the opportunity to send the tip. The prosecution has claimed that Cameron Holmes was downstairs for 10 minutes and thus unable to send the tip. However, the order delivery history that you saw today shows that the pizza was delivered at 9:02, giving Mr. Holmes enough time to get the pizza, come back upstairs, and send the false tip at 9:08 p.m. Your Honor, there were 3 people in the apartment the night the tip was sent. 2 people besides Miss Klein with the means, the motive, and the opportunity to send the false tip. Moreover, you heard from 2 expert witnesses today, Dr. Dakota Chung and Dr. Blake Williams. Dr. Chung's analysis was not comprehensive, as Dr. Chung only focused on the features present in the tip. And recall that Dr. Chung cannot even say for certain that Miss Klein was the author. However, the other expert you heard from today, Dr. Blake Williams, who used the standard, time-tested method of linguistics that examines both features and vocabulary choices, concluded that the author of the text-to-tip could not have been Miss Klein. All the evidence that we have tonight is circumstantial evidence. And according to Calcrim 224, where there are 2 reasonable conclusions from this circumstantial evidence, the court must side with the conclusion that points to Miss Klein's innocence. Tonight we have 2 reasonable conclusions. The second conclusion being that Mr. Holmes wrote and sent the tip. A conclusion that not only points to the innocence of Miss Klein, but is even more reasonable. Today the prosecution has failed to carry their burden. They have failed to prove to you beyond a reasonable doubt that Miss Klein is guilty of false report. There is not enough evidence particular to Miss Klein for this court to convict her. For these reasons, the verdict that is just, appropriate, and correct is one of not guilty. Thank you.
Thank you, counsel. rebuttal from the
Yes, Your
prosecution?
May I proceed?
You may.
Opposing counsel is correct in stating that actions speak louder than words. But in this case, Your Honor, the defendant's actions point to her being guilty. Her actions of checking the phone at 9/11, showing that she saw the text tip and didn't report it, therefore showing that she sent it. Your Honor, opposing counsel states that Dr. Blake Williams was able to prove that the defendant didn't. But Your Honor, their testimony is not credible, as tonight they were impeached on the stand.
30 seconds.
Your Honor, the people of the state of California have met our burden of proof. We have proven each element beyond a reasonable doubt. Therefore, the people of the state of California respectfully request a verdict of guilty. Thank you.
Thank you, counsel. Rebuttal from the defense?
Yes, Your Honor. May I proceed?
You may.
Love, hate, scorn, and friendships gone bad. Your Honor, this is a case about friendships gone bad. Cameron Holmes was jealous of losing his best friend, Miss Patterson, to Reagan Klein. Cameron Holmes thought that Miss Klein was a jerk and was willing to frame Miss Klein for false report of an emergency. Mr. Holmes had the motive. And you heard tonight from Miss Patterson and Miss Klein that Mr. Holmes also had the means and the opportunity.
30 seconds.
This provides reasonable doubt. Reasonable doubt combined with the order delivery history and the testimony of these two witnesses shows that Miss Klein cannot be found guilty of false report of an emergency. Your Honor, when Miss Klein looked at her phone, she was looking at the time, not for the text to tip. And this explains why she did not see the tip on the screen. Your Honor, Miss Klein cannot be found guilty of false report of an emergency. Thank you.
Thank you, counsel. Both sides now have an opportunity to inform the court whether there are any irregularities that they would like to bring to my attention. Does anyone have anything to bring to my attention?
None from the people, Your Honor.
None from the defense, Your Honor.
And I believe at this time, because the Constitutional Rights Foundation wants to ensure that the scores are counted quickly, they would like to have the score sheets collected immediately. So before delivering the verdict, we'll await that.
We'll take it for nomination.
Yes.
I think on the key page here, you want to do, yeah. They want to. You do want to.
Right, Ben, if you're done with them.
intent to require that. Just look at the scoring, so.
I'm going to deliver the verdict at this time, and the sheets will continue to be collected. Of course, the verdict and the ruling do not reflect the score that is given. They are usually independent of one another. They sometimes do match, and sometimes they don't. This is the verdict on the one and only remaining count, count 1. There is no direct evidence that Reagan sent the tip text. There is, however, substantial circumstantial evidence that she did so. If 2 or more reasonable conclusions may be drawn from the circumstantial evidence, and one of those reasonable conclusions points to innocence, while the other points to guilt, the court must accept the one that points to innocence. In this case, however, the only reasonable conclusion the court can draw from the facts is one that points to guilt. A debt-laden, unemployed student who thought she was facing a $34,000 lawsuit, and upon whom the victim had blown the whistle about a valuable stove, Ms. Klein had a powerful motive to harm Mr. Smith. In addition to this powerful motive, she had the opportunity to use and was seen holding Cameron's phone at or about the time the text was sent. The court finds that the only reasonable conclusion to draw from these facts is that Ms. Klein is guilty on count 1. Ms. Klein is remanded to the custody of the bailiff. She is, of course, acquitted on count 2, as we know, because that was dismissed earlier. At this time, there's nothing more to say that I am utterly startled by the extraordinary competence of both sides. Congratulations, you can now breathe freely and enjoy your day. I'm now going to turn to the attorney scorers to give their comments, because I know that it'll take a little bit of time to count the scores. Mr. Cravaro, starting with you.
Thank you, Your Honor. I concur with the court. I've been doing these rounds many, many years, and this is probably, I think, the finest 2 schools for the final round that I've ever seen. I am so happy that I got to be a scorer instead of the judge. You gave this poor court such a workout with the evidence code today. It was like a class in evidence. So that, to me, is very impressive, because that really means that that's a level beyond of your understanding of the problem and how hard you've worked. This is not just rote memory that we saw today, so I really congratulate both of you. I also thought that our appellate attorneys who did the pre-trial motion were excellent, because the court would ask very good questions, and you certainly knew the case law, you knew how to distinguish it from the facts at bar, and that's a really distinctive skill that is much different than being a trial lawyer. And because you never know exactly the questions the court may ask, you can anticipate, and the court, of course, you can't memorize the argument, because the court is going to insert or ask those questions. So my congratulations really to our appellate lawyers. That also was an excellent skill. Tremendous understanding. I know that you really had to work very, very hard. Before we move any further, as much as that's your brother I see back there, I have seen the future. We have an alumni of our program here in our audience also. I have seen the future of the law firm of Munch and Munch. Prosecutor superb as you were today also. Congratulations. I remember, I believe last year you were a witness, weren't you?
I was actually an attorney last year.
Attorney, but You have improved over the year.
Thank you
and
very much, sir.
Fantastic. Congratulations very much on that. Just a couple of brief comments. The witnesses were excellent today also. The attorneys, and for the audience, you really can't get the gist of it without the witnesses trying to be good actors, as I believe they were today. So all of you did an outstanding job. A little bit of fun for the audience to tip you off. Our court, in granting the motion, left one count. You recall that I saw our attorneys scrambling because the court then read both counts, so I saw the prosecutors quickly writing notes, don't talk about the other. So that was something that also, again, is a great testament to the fact that you understood the problem and that you really accomplished something. One of the great things about the program, whether we joke whether or not any of you will go on to be law or prominent attorneys or a judge someday, that's not really what this is about. This is about your opportunity to demonstrate the fact that you can take a complex set of facts, compare it with the law, understand the third branch of government and participate in it with a real judge, understand the rules of evidence, and that accomplish something on your own. You have proved to yourself that you are capable of so much. And it is to your personal accomplishment today that I congratulate you. I know that this is a contest and that one of you will go on, and whoever goes on to the state finals that represent our county, I am convinced that we are going to be very, very well represented. But it is so much more, so that all of the participants today, whoever wins and whoever doesn't get to go on, that's really not the point of it. You all were winners today. I also really want to thank our teachers out there who have brought you to this point, our parents who are here today and supporting you, and our attorney coaches. They, I know, are overwhelmed with emotion and pride, as I am, in seeing how well these teams have done. This is an accomplishment. We hear too much about the youth of today and the lack of civics education. And the adults in this room who have brought you to this point, they deserve a round of applause. The faith that they have demonstrated in the next generation of leaders here is overwhelming. And I know it's a burden, guys, but it's something that I think that you are being well prepared for. So I congratulate you. We're not going to go into too many individual comments. I'll let my colleagues do that, but just a couple of things that caught my eye. Again, we talked about how excellent the evidence objections were and the workout that you gave our court judge this afternoon, particularly being a Saturday. On the other hand, there's a couple of things. I'm not so sure that our analysis, our experts about, I'm not sure that this is actually what would come within the purview of scientific evidence. And I know that you've heard about scientific certainty. I'm not sure that that's exactly as it would go, having had experts like this myself. I also want to comment on just a couple of interesting things for our audience about the close. In this particular case, the basic elements of the crime are almost a given. We have uncontested testimony by a police officer and the witness. What really is at issue is an element of identification, that which is on beyond a reasonable doubt. So as a defense lawyer, having done this many times, one of the things to gain credibility is to simply concede that those elements of the crime have been made. However, there is insufficient proof for the identity of the defendant. That's exactly what our defense did today, and in the business we sometimes jokingly refer to as the Saudi defense. Those are just stands for some other dude did it, and that's exactly what they argued today. Our prosecution, on the other hand, did that, and as you heard the court, there was no one actually saw doing the text. What we had was circumstantial evidence, which in our state is as good as direct evidence, and that is why the court made her decision as she did today. So well done on the closing arguments in that. Again, one other thing I might point out for the defense, it would not necessarily, in this particular case, in criminal law, unfortunately, words do speak as loud as actions at times. They in themselves, can be the crime. So I don't know about that theme as much. And in this particular case, the court is really finding not so much that the client, let's take it on the other way, if some other dude had done it, which is what you try to point out. It's not necessarily that the defendant is innocent, but rather that there was simply insufficient evidence for the court to find beyond a reasonable doubt. Those are two different concepts in our law, and people get confused about that, most members of the public. So I hope today, the members of the audience who may think, you know, I don't know if I agree with the court or not, you have to, in your heart of hearts, hearing all the evidence, if you don't agree, say that there certainly is something that you would really raise your eyebrows about the behavior of the defendant and the reasons that the court did. So innocence in our law, when someone is not convicted, does not necessarily mean they didn't do something. It's simply that the burden, which is the highest we have in the world, simply was not proved, but it was today. So with that, I congratulate everybody, and I turn it over to my colleague. Thank you.
I know many of you, you've been to this round before, and I have also scored it before. For those of you who don't know me, as president of the Orange County Trial Lawyers, it is an organization of trial lawyers. I've had many trials, I've watched many trials, and I have to tell you, you guys are right up there with the attorneys that actually practice law. And you're actually better than a lot of attorneys that practice law. You know your objections, you think really quickly on your feet, and that also goes on the criminal side. You can tell why you are at this level, okay? Because you're not just going through a script. And I have to comment on the witnesses today. You guys were so believable. And that helps in your case, right? Whether you're a prosecution side or the defense side, because as attorneys, you're trying to get that rapport with your witness. And if your witness is just, kind of memorizing and going off the script, it's not going to be very good. It's just going to be a very regimented, kind of scripted presentation today. So, witnesses, great job. Just use your voice a little bit. Got to be a little bit louder. And let's see, on objections. I know you try to throw them off, okay, but make sure you know your objections, okay? Just polish that up a little bit. Whoever goes forward to the next round, it gets even that much tougher, okay? So polish them up. And when you're throwing out objections, make sure you understand your objections. You're going to have strong arguments behind them. And then lastly, as a form of constructive criticism, the judge struck count 2. Okay, so a lot of facts that are in your fact pattern go to count 2. And there were some, I think on the prosecution side, maybe ran out of time. Don't focus so much on those facts then, okay? Use them, hit them, and run, right? Because you can say that those were for motive, right? That person had the motive. But you don't have to hammer them so much because a lot of those arguments would go to count 2. Okay, so great job. I mean, I'm sure I would repeat a lot of the comments that were already stated, but good luck on the next round.
I say ditto to everything that Geraldine has said and my colleague has said. I haven't ever judged this round. I've judged a lot of rounds at a lot of different levels for many years. But again, you all were just absolutely amazing. And I just have to say, as a female trial lawyer, I'm happy to see so many young women and to see how you women are carrying yourself, and nothing against the guys. But I mean, I think all of you struck such an amazing balance between just a level of professionalism and yet a real approachability. And I love to see that because that's what jurors often really appeal to. They really are attracted to that. One thing I want to say in terms of something I observed, and I'm just going to do a couple observations on specific individuals. Jurors are watching you at all times, and they're watching you in the elevator, they're watching you when you're talking, they're watching you when you're not talking, they're watching how you cross your legs, what shoes you're wearing, how straight you're standing. But I just want to say that I noticed so much that Ms. Lopez, you always maintained just complete straight posture. You always sat when you were not talking or whether you were talking with just a complete level of professionalism. And I really noticed that, and that was amazing, and I really want to commend you on that going forward. The fact that I'm singling some people out doesn't mean that I didn't think everybody wasn't amazing, but usually I go off of my handwritten notes, which have already been collected, so I just have to go off my memory right now. I have to say that, Mr. Cho, I thought that you were so professorial in your in the pretrial argument. I thought that you, you know, there's always such a tension when you're not going to use your notes, and at this level, nobody used their notes, of course, for when you were speaking. But you don't want to sound like you're just just rotely trying to get everything out that you memorized. And you spoke with so much emotion, and you spoke with so much conviction. And then when you came up as a witness and just hammed it up, and were like kind of this. You really took on a different personality. It really showed a lot of your versatility, which is really an amazing quality for a lawyer. Again, I would say that, I forget the young lady, is it Kara that did the closing?
Kana. Kana.
Okay. I thought your use of emotion and your movement around the courtroom was really very impactful. You talked with a lot of emotion, you used your hands, your voice fluctuated a lot, and it was actually very easy to listen to you and follow your argument, even though you didn't eventually win. But I really want to commend you for that. And again, I will sit down, but those are just some of the things that really stood out to me. And so I really want to thank you for the privilege of judging this level of competition.
I'll stand also. I've been privileged to actually preside over one of the earlier rounds for the prosecution. And you did a wonderful job. I'm just going to single you out only because I have the experience of that. And you've improved a lot, very frankly. So it shows a lot about the benefit of going round to round, and it's a wonderful experience. And of course, the more competitive it is, the further you go, the better you become. Because as with a tennis match, having a good opponent on the other side will cause you to play better. And you really have both sides. I haven't had the opportunity to observe Veritas previously. You did a wonderful job. I think both of you used a theme really effectively. And the means, motive, and opportunity actually is a very traditional one in the mock trial, and it worked really well for you. As well, on your side, your literary quote fit really well here and pulled us back in. I thought the witnesses were great. I've always felt direct is in many ways more difficult than cross-examination, although the cross attorneys were terrific, just really good. I know it was somewhat confusing with the result of the pretrial and trying to roll back to cut that out. And I'm sure whoever goes on you'll be very adept at addressing that if it occurs in the future. But also as a test of how good you are to deal with that. I'm sure that Judge Saunders sort of threw you an opportunity. As with
That's how it was intended. I also didn't intend to read count 2, of course. So that's threw you another opportunity to show how good you are.
But just in general, with the questions during, pre-trial, a lot of it is to allow you to show, how much you really do know. And I think in pre-trial, you really got into the cases really well. And how they, to think back, compare it to our factors, really good. In terms of the witnesses, I thought the person who played Mr. Colostian was just really terrific. You would think he had a business. Expressive, natural, just everything you want in a witness, and it takes a good attorney on direct to bring that out, because we really do want to focus on the witness. I thought on the prosecution side, the officer played it just terrifically. So all the way around, both teams, you're great. It's a great opportunity. It's a really unusual kind of tactic, and good luck.
Hello again, I'm Lisa Patrick, and I want to actually take a little bit of a different approach and not give you all the warm fuzzies. You guys know you're great or you wouldn't be here. I'm really pleased to see two new schools get here too. So it's really exciting to hope that one of you keeps going. And so what I want to do is give you a little bit of things you can use going forward that might have been a little bit on the less positive side. So first thought though, has already been said, teacher coaches, attorney coaches, you're the ones that get these kids to this point. So I would give you a standing ovation for Mark Scanlon. It goes to show the investment that you've made, especially over the years with some of the schools. So really good to get here. But now that you want to keep going, here's a couple of things. One of the big ones was, let me ask you guys if you think you know one thing you didn't do that you wish you'd have done. Prosecution. Defense. Nobody says time check. Time checks. Huge thing here that the prosecution brought this great clerk. And if nothing else, you want to show off your clerk's great skills, that they are on it when they're asked. And you didn't really give your clerk an opportunity to shine. So if you keep going in the other school, either way, your prosecution team's going to get up. Let your clerk and your bailiff shine. Bailiff did a great job following the witnesses, being very officer-like, watching over the defendant. Those are, high points. You can get 5s just right off the top. The other thing you probably have been told by your coaches over and over, slow down, enunciate, make your words clear, have a pace. And most of you did that. There were a few times that you didn't, and these two things kind of go together because you have time constraints, therefore you have to talk within that time constraint so you don't get stopped. That was awful to get stopped in your closing, so you can't let that happen if you go on. If you sense you're running out of time, then just end it. Pick a good spot, end it. You can always pick it up on rebuttal, but don't ever get stopped. Time checks help prevent that. The other thing was on the exhibits. This was a heavy exhibit year. We had a lot of them. You guys kind of used them better than some of the other rounds. I scored a lot of the rounds this year and last year, many other years. I've tried dozens of cases to a judge and to a jury, and so I'm giving you some experience, that, not just the rules of my trial. But you didn't really do the exhibits well getting them in. Most of the time you got to show foundation. Why is this exhibit what it is? Do you have a witness or somebody that can show that it fairly and accurately depicts that what's on the exhibit? Or a stipulation to speed it up. You could propose a stipulation either on the record or with your opponent. If your opponent agrees, you don't even have to go through all that stuff. So consider that as an option. When you get it in, use it. You guys didn't really use the exhibits. I think defense closing proposed, can I approach the exhibits? I never went anywhere near them. So in this courtroom, it's a little bit tougher because this is a long walk from here to there versus some of the other courtrooms. Time issue. So maybe the more you get comfortable walking around the courtrooms, if you have permission to move around, hang out near the exhibits when your witness is up there. And that was one of the other things. I didn't like you asking the witness to deal with the exhibits. The experts maybe, because they wrote the exhibit, they made it theoretically, it's their baby. But the other witness, to ask them to rearrange it, is that a point matter? Probably not, but it's just one of those things where if you're the attorney and you're in control, you go do it. You take care of the housekeeping for your witness. And it gives you a closer interaction with them. Also, maybe Judge Saunders can weigh in about the may I be heards. It feels so weird when you make an objection, your opponent just called you out on something and you want to be heard, then maybe you don't need to be. If Judge Saunders, or sustains the objection, then you don't have to get up and respond. And, granted, not show what you know, but maybe wait until the judge makes a ruling. I saw Judge Saunders kind of looking like maybe she was thinking and could use the input of the opponent. But I think the normal attorney reaction is to maybe not jump quite so much and so quick, because it just doesn't look like, it looks like you're nervous. And then when you're nervous, that doesn't help in the long run. Judge Saunders, do you agree or disagree?
I like it when not attorneys in a real trial, but in this situation, asked to be heard, because I think it is important that they demonstrate their knowledge of evidence. And at times there was some confusion between hearsay and foundation, and I wanted to try and figure out whether they understood the real basis for the objections. So I like the may I be heard, because it gives the students an opportunity to reflect their knowledge.
In real life, we do get in trouble.
You would in real life. That is one of the things that I would not occur in a normal courtroom, yes.
The only
Typically.
other thing I have to add, I have a lot of student individual comments, and I put them on my sheets. For the most part, I tried to give all the witnesses a comment. And I have to say, too, that I agree this year, or at least this round, seems heavily points towards the witnesses. I'm asking myself as I stand here, who did I score best? I have no idea, because I really scored everybody individually. So each one of you counts towards whatever the outcome is going to be. And you pulled the weight, or you didn't. Most of you did great, especially the witnesses. The two experts, awesome portrayal of experts, awesome responding to the crosses, being challenged. It was really good. But final comment, attorneys, cross-examination. When you want to say da-da-da-da-da, correct, da-da-da-da-da, correct, 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 it gets like a broken record. Mix it up. How about right? You did it a couple of times, Ms. Munch. Just yes or no, here's my question. Or true or false, here's my question. Or like I wrote a list, you could say right, you could say isn't that true, you could say isn't that so, just yes or no, on and on and on. But just don't do correct, 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 correct. That is a weakness in cross. So overall, I'm sure everybody else has a few more comments. Best of luck to whoever goes on. We know you'll do well in representing Orange County, and we hope that you will come back next year and do it again, because I can't wait to see the change.
All I'll say is congrats on getting this far, and no matter who wins, you both did great.
I too am going to end on a positive note. It truly was a privilege to be able to just watch, let alone be one of the scorekeepers for this round. I think every one of you should be profoundly proud of yourselves. I know your coaches are. If half of you go into law, it is a very good omen for the bar. I'm going to give you each one pointer that I would carry away on the prosecution, other than time management, is make sure that you pay attention to your objections and understand your bases. Okay. For the defense, on closing, make sure your theme really actually matches. I think we were going to have a hard time proving your client really was pure and golden in heart. We had plenty of evidence to show and to call into question the issues, and that distracts from the actual evidence and the weakness in the prosecution's case. But it was really amazing watching each of you. You show profound poise. You show a dignity in practice that is often missing in the courthouse. Your command of the facts of the case, the nuances of the case, was evident at every level of this competition. And on a final note, although you were all masterful, I was stunned at the skillful presentation on the pretrial arguments. You should both be amazed and very proud of your performances. I know that everyone here wants to know who won, and I know none of us know, so I'm
I have only one comment. You managed to show confidence but respect for the court without once saying, with all due respect. So,
Your Honor, they learned that a long time ago. That's not respectful.
not once. Are you ready?
Oh.
And the winner is Veritas Classical Wonderful. Go forth, enjoy your dinner tonight, and you may leave, Miss Klein. You do not have to remain in the cage. Take care. Good luck.
Right next to the counter.
First time I've done this for many, many years. I used to go to the restaurant store. And so I've never seen your They're not just doing well, they're beating out some Irvine teams, which is really good. Well, bailiff, yeah, you got to get those 5 points. It's not that hard to do, but one of the things you did, which was great, was you followed your winners. A lot of them, like, lead them. Like, if they had a gun to their back, they would never know.